Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the recovery addict, and boy, do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy there.
Got the wrong guy, and the dog was biting him.
He roughened him up quite a bit. There's a lawsuit.
9 out of 10 judges prefer watching the Recovery Addict live stream in their court.
The fireworks are not done.
Now we're getting commentary on the case. Dati mihi Anglican po in servers Latinos.
All right, I was in the middle of multitasking this morning. Good morning, by the way. Good morning. Welcome to the Court of Public Opinion. I am a recovery addict. Good to have you here this morning. Late start this morning. Late start. I was in the middle of starting to take Matthew Harris's quiz. I've got it pulled up on my computer, and I'm not doing so hot. Oh wait, I can go back and correct my answers. Wait, I've got 100%. Sorry, I misspoke there earlier. I'm doing great on my quiz so far. So I've got a few more questions yet left to answer on that one. Love having the quiz this morning to get my brain going. I will say also this morning, early this morning, we had someone in chat whose name I'm searching for, frantically. You know who you are, Crusoe. I know you're here because you were here first. I just need to find you again. Say something. Come out from hiding. We know where you are, and you know why I'm calling your name.
I was kicked back, taking it easy.
It's not because you're in trouble. Well, you sort of are, but Crusoe was first in chat this morning, and first in chat comes with its prize. It has a prize that goes with it. And that is that you are awarded the internet and everything IP related for the morning until we go live again. So Crusoe, I know you're laying low right now. You're hiding, maybe trying to shirk your responsibility a little bit, or maybe you've just stepped away from the keyboard and can't respond right now. Maybe you're driving or something like that. And in that case, don't type anything. But just know that you have won the internet. And it's all on your shoulders now. I believe this is a first-time offense for you. First-time winner, sorry, excuse me. It's so easy to mistake the prize and the punishment that goes along with this. But I think you're going to do great. So thank you very much. I appreciate you being first. Let's see. I thought I got a message from Matthew. It was somebody else. It would have been really funny if that was the message from Matthew because of what the message was. But I can't share it with you, unfortunately. Just know that something really funny just happened and I can't share it. I apologize. My mouse is stuck. There we go. Okay. Now we're good. All right. We've got a sort of a short morning. Well, we started late is what happened. There we go. Waiting for Miss Gwyneth. I think something's happened in the ice cream murder trial. I'm not sure exactly what's up there this morning. I do see some action happening. Who's saying buffer? The verdict is in the ice cream murder trial. Okay, so I just pulled it up on the screen. I just saw some motion down there. Sharon McDonald. Does anyone have got a birthday today? Yeah, whose birthday present is Squirrel. Is the verdict in the ice cream murder trial? This will be interesting. Thank you, Amber, for the verdict notification. It just caught my eye right as I was watching it. So we'll have the audio from that we'll be following. We're expecting in about half an hour. We're expecting the Gwyneth Paltrow case to start. So we're probably going to have some overlap there. But there are some other things I wanted to talk about this morning as well that are sort of pressing and interesting. First of all, over on the Discord, we mentioned Discord a lot of times, and it's come to my attention because, quite frankly, I'm guilty of this myself. is that a lot of people don't understand just how amazing Discord is. And I can get lost in there pretty easily. There's a ton of information. But about half of the people who have joined the Discord page can't even see any of the information because they haven't clicked on like the 2 buttons they need to what's called roll up to get access to everything. So tomorrow morning, we're going to do a little live stream with Amber, Calypson's Vixen, who's one of the mods over on the Discord page. She's going to walk us through, as a new user, what buttons you click and how to get access to the Discord page, because about 350 of you know absolutely nothing about the true crime benefits of being a member of the Discord because you can't see it. Now, it's not your fault. Discord has a learning curve, and we understand that. We're going to try to help you with that. Amber's agreed to wake up early and get everything set up. She's going to Zoom in, and we'll have just a little seminar, one-on-one, quick little walkthrough that'll get you started, and it will open your eyes to the wealth of information that's out there. So we're excited about that. That's going to happen tomorrow. Thanks, Amber, for doing the dry run today. That worked great. Let's see. Somebody's waving. Hi. Hey. Call me. Yeah. And she's down. All right. Let's see. There's the defendant. This is the ice cream trial right there. Another Wisconsin murder trial starting in Kenosha with Mark Jensen judge. Nice. I promise the whole state isn't like this. It's super chill up north. I swear, says Ivan. Yeah, that's going to be the, is that the Alan, I think it's Alan Brown or something. Alan Brown. He's, I think it starts with like a police chase with him. And I'm not sure if it was like a car chase or like a foot chase. And at some point, a canine is released. The fur missile goes after him. He shoots at the police officers. He actually shoots at the dog and hits the dog. And the dog sustained a bullet wound to the forehead and will make a full recovery, apparently. The dog is that tough. They ended up capturing this guy. The dog really saved the officers' lives in the process of all this. So that trial's it's starting. Is it in jury selection this morning, or is it starting on testimony? Does anybody know? I haven't seen. What case is the Camel judge doing? That would be this Alan Brown. All rise. Okay, let's get our super source box set up so we can follow everything that's happening this morning. And give me just 1 minute here. Box source 1 is going to be Ice Cream Man. Box 2 will be Miss Gwyneth. And I will be in box 3. How about that? Let's go there. Okay, here we have, this is what our morning looks like right now.
I was kicked back, taking it easy.
Chat is not on screen. I will fix that. Chat is now on screen. Thank you, Thomas, for that. I was looking for Crusoe, and I wasn't going to put chat on screen until I found him, but bingo. I'm already on like 80 Discord pages. I can't handle more unless I start deleting some. Crusoe, you're now in charge of the internet on top of that. So congratulations on winning that. It's going to be awesome for you. Today will just be epic. Okay, let's get set where we need to be. Another information bit about Discord, because they have grown so much in size, as so many people have joined them, they have reached a threshold, a new level where another option is available to them. That includes, I believe it's a banner for the page, a top page banner. So they may be doing a poll or a contest here soon to design the Discord page for As the Gavel Drops. So we'll watch for more information on that, and possibly it will be over there as well as we'll plug it a little bit over here as well. Okay. I get lost in Discord StreamYard. Under Your Scars, I need help with StreamYard. I was playing with that this morning. I was actually tempted to dual stream the case, the video today, using StreamYard to push to Facebook, and I use my desktop device to push to YouTube. But I struggle with the audio loops. StreamYard wants to be everything for everyone. It wants all the feeds to come into that, and it wants all the audio to work through that. Well, I run everything externally, and so trying to get the audio to work out is crazy. Have you looked into the plastic surgeon charged with murder? Yes, that's the one that happened in the bathroom, right? The lawyer went to I think it was a lawyer, went into the bathroom and never walked out again. I looked a little bit into that. That's going to be interesting as well. Mary Murphy, if you know, is the trial starting on jury selection today, or is it starting with testimony today? Okay. Amber's super excited to do the Discord demo. It's like a dance, the Discord disco, for everyone. I've seen it help Sony that I've done a demo with one-on-one. The feedback's been fantastic. I really agree. She walked me through, and it was pretty good. We're going to tweak a couple things to make it a little bit better for you guys tomorrow, and it's going to be amazing. Cue the circus music. No, the Gwyneth Paltrow case has a few more minutes before it starts. I'll hold on the music for just a minute. We've got the ice cream case. No audio yet on this one. We're waiting for the audio feed. Of course, he's just talking with his lawyer, so we shouldn't hear that anyway. Mad Cow Mark, welcome. Good to have you here. The Discord page won't let me sign in and chat for some reason. Randy, I think that's what we're trying to fix. The roll-up feature is where people are getting lost. They connect, and then they can't really go further than that. Unless you actually don't remember your login for Discord, that might be another problem. I'm not sure if we can help you with that or not. Let's see, Rosie, missed you yesterday, but I'm back today, and you brought the donuts or cinnamon rolls, so thank you. Not a camel. Camel Judge has a new trial. I'm not a camel. Let's see. Liking would be appropriate right now before the action gets started. This is a great time for conversion from lurker to liker because the ratio is 0.26515151515152. Thank you very much, KQD, for that. Doing the hard math first thing in the morning. Let's see.
I'm not a camel.
There he is. Not a cat or a camel. Fun things in the Gwyneth Paltrow case. Really, the exciting stuff is not the testimony and the information, the testimony and evidence in the trial, so to speak. The fun stuff is what's going on with the lawyers, the back and forth. I would say the spite, the childish arguing. It's like next level. It's so amazing. It's so entertaining as well. The funny thing that ended the day yesterday, if you didn't catch the very end of the trial, I don't blame you. It happens very late in the day. The defense basically was complaining, saying, look, Your Honor, plaintiff side said they were going to rest on Friday, and here it is, the end of Monday. They still haven't rested. They're still saying we're going to take a little bit more time on Tuesday, and I need my time to present the case because this is not like a normal criminal trial where it takes as long as it takes. We've had Zachariah Anderson went 2 weeks longer than they expected. Nope, this civil case, there is a hard stop. The judges said this is the date that we will end. We will hand this over to the jury at this time. And within a little bit, and everything has to happen before then. So they just have to work with each other, and it's like a lot like playing chess, where you have the clock, where you hit you go and you hit the button, then it counts down on the other person, and they hit the button that counts down on your time. So you each have equal time that you're supposed to be using, and the judge has that information, and you can basically run out of time before you run out of court, and if you don't have any time left, then the other side can't do a cross. It's really funny, and so it's like a next level of chess for attorneys. But defense is actually Mr. Owens is in a little bit of a bind because he's like, I have 7 expert witnesses for tomorrow. 7 expert witnesses. Now, unless he can handle these differently than we've ever seen expert witnesses, there will not be 7 expert witnesses on the stand today. They'll have to be like 5 minutes each to make that happen. And then the cross and everything, it's going to be amazing to see this all go down, because basically they're going to have to speed read and speed talk and not ask any questions. Is there a verdict? I hear there is a verdict. That's what I hear. We're sort of watching, hoping things happen here. before Gwyneth Paltrow's case kicks off. Are we thinking guilty or not guilty? I don't know, Miranda. I know enough information that I have a general overview of the case. I did not follow the evidence and the testimony in this one. It's I think
Bring the jury.
I think it's pretty clear that he was seeking some revenge. To me, I love this chair, Sarah. This is amazing. I think it's clear he was seeking revenge. I don't know if they've proved that it was him that did the shooting. That was somebody found the new command. Who was that? Oh, it was you, Amber. You found the new command. I didn't say anything about it. Are you using an Apple device, Jeanette? Jeanette, are you having some trouble with something? I use a lot of Apple devices. 6 of them, as a matter of fact, to make the stream happen. Yes, you're going to want to go through Safari and try to connect that way through the channel page and join on Safari.
Kick back, taking it easy.
Jill Martin, what did Ice Cream Man do? Apparently, he...
You're talking about stuff that is not relevant.
The allegation is that he hunted down the people who robbed him, went, I guess, to the wrong house. There were like 5 or 6 young men on the porch. He walked up in a police officer's outfit, a costume, with the gun, ordered them all to lay on the ground, took their IDs and was looking at them, and then proceeded to shoot them as they were laying on the ground. Killed 2 and wounded 4 or something like that. That's my understanding. Not good for anyone to do. But I'm not sure if they proved that it was him. That's my concern. Okay, I think I need to fix the too frequent response for Amber's laugh as well, because it says cackle. I copied the cackle command to make that work. Let's see. If you plug a wattage counter into your wall, you'll notice the 6 devices using about 5 times what a PC would. Yeah, probably. I don't doubt that at all. Because some of these devices as well are powering things over USB that draw a lot of current, that have to have 2 USB-C outputs together to power the device. So it's drawing a lot of power. But I bought into the Apple ecosystem years ago, and it's expensive to get out. Mom Marley, thank you for hitting the subscribe button. Welcome. We are slowly inching our way closer to 10,000 subscribers. The chat thinks that in LNC, the chat thinks Ice Cream Guy is going to be not guilty, found not guilty. Looks like there's a little bit of motion. People might be taking their seats here. Hopefully they have something soon. Do we know the time for the...
Thank you very much.
Here we go.
Good morning, everyone.
Apparently it's right now.
Mr. Escobar's mind. Grand jury. We're going to wait for Mr. Grant. Is that correct?
He's on his way back to the center. I've got Gwyneth handling some depositions for another client in another jurisdiction as well. It would not be fair to our client to wait any longer.
Okay. And State, Ms. Johnson.
She's not going to be here, Judge. We can go forward.
So we have everyone.
We do, Judge.
All right, including Mr. Keatley. All right, it's my understanding the bailiffs have informed me that the jury indicated that they have a verdict. So what we're going to do is we're going to bring them out. I will receive the verdict from them. I will review it to make sure that it is signed and dated and that anything that needs to be checked is appropriately checked. I will hand it to the clerk to be published. All right, let's get the jury.
Okay, so we might have this done before I was going to say Amber Heard. Gwyneth Paltrow's case starts. Jeanette French, thank you for finding the way to the button. It looks like you got that green courthouse by your name after all. Appreciate you so much for your continued support of the channel. Okay, let's see. I thought we got a new judge for Gwyneth. No, Gwyneth is up above me, right here. This is Gwyneth, and this, whoops, this is Ice Cream Man. So Ice Cream Man, the verdict just came in this morning. I think... sorry, I'm trying to see on the Ice Cream Man. It looked like the monitor was steaming or something. I guess it was just a reflection. But the verdict just came in for him, so we want to follow that this morning. We're going to check that out.
I asked them the question that I always ask them to make sure that they didn't have any discussions or exposure to the case between the time they left yesterday and they returned this morning to begin deliberating.
I really think if they had a verdict first thing in the morning, they probably reached it last night and then wanted to sleep on it, and then got there in the morning and said, okay, yep, we're still there. With it being a verdict on this video, I can 100% guarantee you that a certain company is going to copyright claim my video out of the UK. They hit me with 3 yesterday as well. Wow, they're fun to deal with. Yes, this is the one, Gail. He's been in jail for a long time.
You are.
All rise, jury, entering courtroom.
Jury is present and seated. Everyone else can be seated at this time. Ladies and gentlemen of the jury, good morning and welcome back. The first question that I have of you is my first opportunity this morning to see you is just to ensure that no one discussed this case amongst themselves or with anyone else, or did any research or was exposed to anything about this case between the time that you left the courtroom yesterday when I sent you home at approximately 5:30 and the time that you returned back this morning. It's my understanding the evidence was delivered to you at 8:35 this morning to begin deliberating. So between those times, the time you left yesterday at 5:30 and the time you returned and began deliberating again at 8:35 this morning, by show of hands, anyone discuss this case, do any research related to this case, or exposed to this case in any way?
The answer is no.
Let the record reflect that there are no hands. Again, thank you all very much. It's my understanding the bailiffs have indicated that the jury has reached a verdict in this case. My first question is usually, were you able to select a foreperson and who that foreperson is? But because we had a communication from the jury yesterday regarding the readback, I know that the foreperson is, I almost said your name, I'm not going to say your name, it's number 6. Previously number 48, but seated in number 6, initials JS. So, Mr. JS, my question then is to you. You are the foreperson, correct?
Yes, Your Honor, I am.
All right. Has this jury reached a unanimous verdict in this case?
Yes, Your Honor.
Do you have the verdict form?
Yes, I do, Your Honor.
Would you please present it to the bailiff, and thank you very much. I will review it, and then I will give it to the clerk to be published.
As he's reviewing that, we want to wish a happy birthday to Marilyn Skoll. Marilyn, happy birthday today. It was awesome to bump into you on another live stream last night. I think Red Pen was over there as well, and there might be a couple others. We were watching Danny on Point. On direct. Danny on Point.
All right, Mr. Keatley, if you will please stand for the publishing of the verdict, and counsel, you may stand with him. And Madam Clerk, if you will please publish the verdict at this time.
Wow, this is quick.
State of Florida versus Michael Edward Keatley, case number 10 CF 18429. We, the jury, find as follows as to count 1, victims Victor Sergio Guitron. the defendant is guilty of murder in the first degree as charged. And 1, did the defendant personally carry, display, use, threaten, or attempt to use a firearm? Yes. Number 2, did the defendant actually possess a firearm? Yes. Number 3, did the defendant discharge the firearm? Yes. Number 4, did the discharge of the firearm cause the death of Sergio Guitron? Yes. We, the jury, find as follows as to count 2, victim Juan Guitron. A, the defendant is guilty of murder in the first degree as charged. And 1, did the defendant personally carry, display, use, threaten, or attempt to use a firearm? Yes. Number 2, did the defendant actually possess a firearm? Yes. Number 3, did the defendant discharge the firearm? Yes. Number 4, did the discharge of the firearm cause the death of Juan Guitron? Yes. We, the jury, find as follows as to count 3, victim Gonzalo Guevara. A, the defendant is guilty of attempted murder in the first degree as charged. And 1, did the defendant personally carry, display, use, threaten, or attempt to use a firearm? Yes. Number 2, did the defendant actually possess a firearm? Yes. Number 3, did the defendant discharge the firearm? Yes. Number 4, did the discharge of the firearm cause great bodily harm to Gonzalo Guevara? Yes. We, the jury, find as follows as to count 4, victim Daniel Beltran. A, the defendant is guilty of attempted murder in the first degree as charged. Number 1, did the defendant personally carry, display, use, threaten, or attempt to use a firearm? Yes. Number 2, did the defendant actually possess a firearm? Yes. Number 3, did the defendant discharge the firearm? Yes. Number 4, did the discharge of the firearm cause great bodily harm to Daniel Beltran? Yes. We, the jury, find as follows as to count 5, victim Richard Cantu. A, the defendant is guilty of attempted murder in the first degree as charged. Number 1, did the defendant personally carry, display, use, threaten, or attempt to use a firearm? Yes. Number 2, did the defendant actually possess a firearm? Yes. Number 3, did the defendant discharge the firearm? Yes. Number 4, did the discharge of the firearm cause great bodily harm to Richard Cantu? Yes. We, the jury, find as follows as to count 6, victim Ramon Galan. A, the defendant is guilty of attempted murder in the first degree as charged. Number 1, did the defendant personally carry, display, use, threaten, or attempt to use a firearm? Yes. Number 2, did the defendant actually possess a firearm? Yes. Number 3, did the defendant discharge the firearm? Yes. Number 4, did the discharge of the firearm cause great bodily harm to Ramon Galan? Yes. So say we all, dated this 28th day of March 2023, signed by the foreperson J.S.
They're going to pull the jury here.
Would the defense like the jury polled at this time?
Yes, Your Honor.
Ladies and gentlemen of the jury, what that means is the clerk is going to ask each one of you individually whether the verdict that she published is in fact your true verdict in this case. The defense may be seated.
Juror number 1, J.P., is this your true and correct verdict?
It is.
Juror number 2, A.V., is this your true and correct verdict?
Yes, it is.
Juror number 3, J.W., is this your true and correct verdict?
It is.
Juror number 4, RC, is this your true and correct verdict?
Yes, it is.
Juror number 5, CM, is this your true and correct verdict?
Yes.
Juror number 6, JS, is this your true and correct verdict?
It is.
Juror number 7, BH, is this your true and correct verdict?
Yes, ma'am.
Juror number 8, TJ, is this your true and correct verdict?
Yes, ma'am.
Juror number 9, JF, is this your true and correct verdict?
Yes, ma'am.
Juror number 10, EA, is this your true and correct verdict?
Yes, ma'am.
Juror number 11, JW, is this your true and correct verdict? I'm sorry. Juror number 11, JD, is this your true and correct verdict?
Juror number 12.
12 is JD.
Juror number 12,
Yes.
sorry,
It's okay, it is.
is it, okay. And juror number 13, DS, is this your true and correct verdict?
Yes, ma'am. Is there anything from either side before the court releases the jury?
Here you are.
Ladies and gentlemen of the jury, this is my last opportunity to thank you. Throughout the past 4 weeks, I have thanked you for your patience with us.
He's not happy at all.
Service and your attention to this very important case. I'm going to release you now, and I am going to instruct you that all of my previous restrictions about doing research, about looking up things, about talking to others, no longer applies. About watching any of the media reports or social media or anything like that, you're free to do all of that as you wish. Additionally, there is one protection that applies to your deliberations back in the jury room, and you can only be forced to talk about your deliberations through a court order. However, if you wish to talk about your deliberations, you may do that. That is your choice. The last thing that I want to say to you is that now you know what a hard job it is to be a juror. You've deliberated for 3 days now. Many times people tell me as a judge that I have to make hard decisions, and I say no, that's in a trial division for the juries to make the hard decisions. So we all thank you for your very hard work in this case. So at this time, I am going to release you. All rise for the jury.
Okay, we are going to, we might be bailing out here because any second now, Gwyneth Paltrow is going to be starting. I don't know if they're going to do a direct sentencing here in Florida, or if they require like a, what do they call that?
Jury is exited. Everyone may be seated.
The jury's not doing this.
We need to discuss sentencing. Counts 1 and 2 require a mandatory life in prison without the possibility of parole.
So that's done immediately then.
Do you want to set off sentencing?
Judge, I think that would be appropriate.
Okay. Let me check with my judicial assistant who...
Judge, he would also be entitled to a PSI on the remaining
He
counts.
he could waive it, but do you want to waive or do you want to have a PSI?
No, I'd like to have some consultation with him before we make that decision, but if we set off sentencing...
What we'll do is I'll go ahead and order it. The clerk will notate ordered. If you change your mind, we can always cancel it, and I'm going to schedule sentencing beyond 30 days because that's what it normally takes for a PSI. So we'll order a PSI, pre-sentence investigation, and we'll set sentencing more than 38 days out, most likely on a Friday.
We can do either May 19th or May 26th, both at 9 a.m.
So sentencing is going to be in May.
Mr. Escobar, are either of those 19th or 26th preferable?
I mean, just have a quick...
Take your time.
Order a pre-sentence investigation.
And state?
Judge, either of those days would work for the state.
All right.
26 is good.
All right, so we'll do May 26th. Did you say 9 or 9:30? 9 a.m. right here for sentencing, and we've ordered a PSI. I'll ask that you file any post-trial motions at least, let's say, 10 days prior to that, and we'll hear those at 9 a.m. prior to the sentencing. Is there anything else from the state?
No, Your Honor.
Anything from the defense?
No, Your Honor.
All right. Again, thank you all very much. We'll be in recess.
Okay, so that's all from them.
There is one matter. He originally did have a bond.
Oh.
We'd ask that be revoked.
I will revoke all previous bonds in this case at this time.
Thank you, Your Honor.
Okay, so they're done. We're going to bail on that one. Let's go to this guy right here instead. All right, the family over there is very emotional, as you can guess. Getting a guilty verdict after all this time. We're gonna get ready for Gwyneth Paltrow this morning. See what she's wearing. I guess that's why you started Gwyneth Paltrow case. See who she's wearing. Let's see. Though we went through a lot trying to earn a living, I wish he would have did the vigilante thing. The Roberts did him dirty. He got the wrong house, right? Is that the thing? He went to the wrong house. He just assumed that's who they were. He's going to have a bunch of time served, but life without parole, it probably won't matter. Let's see. What was the last hearing? The one we just left from? That was the ice cream murder trial. Sentencing. The jury just came in with a verdict this morning. Mark Warner, is the Wisconsin versus Allen Brown today? Is that jury selection? Can someone tell me if that's jury selection today? This was a retrial that we just watched. The sentencing for. It was a retrial. He had been in custody for like 13 years, 13 years. He was like 2 houses away. Yeah. He wasn't happy with how its testimony. Let's see what we can find here. I'm just going to pull up really quickly the one that started in Kenosha.
By one who intentionally treats an animal in a cruel manner. The state's burden of proof, for you may find a defendant guilty of this offense. The state must prove by evidence which satisfies you beyond a reasonable doubt that the
Judge is
following
reading the charges.
2 elements were present. The elements of the crime the state must prove. Number 1,
they're already down.
An animal, canine rigs, in a cruel manner. Cruel means causing unnecessary and excessive pain or suffering, or unjustifiable injury or death. Number 2, the defendant intentionally treated canine rigs in a cruel manner. Intentionally requires that the defendant acted with the mental purpose to treat the animal in a cruel manner, or was aware that the conduct was practically certain to cause that result. The jury's decision. If you are satisfied beyond a reasonable doubt that both elements of this offense have been proved, you should find the defendant guilty. If you are not so satisfied, you must find the defendant not guilty.
The case we're hearing right now.
If you find the defendant intentionally treated an animal in a cruel manner,
I'm going to turn this down because these are juror instructions. And,
did the defendant cause injury?
This is the beginning of the trial of Wisconsin versus Allen Brown, I believe. That's the guy in the white. He is accused of shooting at police officers as well as shooting at a police dog. The dog was injured. I think it recovered. That's my understanding anyway. This happened back in let's see, when was it?
I'm not a camel.
2021, I believe.
but also the defendant did so while using a dangerous weapon.
It is the not a camel
To find
judge.
the defendant guilty, you must answer the following question. Did the defendant commit the crime of mistreating an animal while using a dangerous weapon? Dangerous weapon means any firearm. Whether loaded or unloaded, a firearm is a weapon that acts by force of gunpowder. Before you may answer this question, yes.
I'm gonna turn this off. These are long jury instructions that they're talking about how they have to prove different elements of the case. We're not going to be sticking with this one today. We are going to follow through with Gwyneth Paltrow just until the end, because it definitely has a hard stop this week. We may go back and catch up with this trial if it becomes one that's very interesting. Why did they pull the jury? For law people, does the jurors ever say the guilty verdict was not theirs? Is it for appeal? There's a chance that there was a juror who did not vote that way, and so the one of them could say, "Hey, no, that wasn't my verdict. I said no," but they said we're just going to go with guilty anyway. That's the opportunity. I have never seen it happen, and I don't know. I don't know if any of the lawyers or legal minds in here have seen that in a case. Perfectly Imperfect. We use copyright material. Today we're using Law and Crime. We use that under the fair use doctrine, where I provide additional insight, value, content, and change and add to the product they produce, and do so in a way that I believe it falls under the fair use laws of the United States. The YouTube process of a copyright is very friendly towards copyright holders, and me fighting it is very risky for me. Fighting it and saying it's fair use. If for some reason they don't agree, I get a strike, and a strike is not good. It ends up that they get a few dollars from me, and I don't get any ad revenue from the video, but they allow me to continue to use the material. And for me, it's more beneficial to continue to use the material and just deal with the frustration than fight it. So maybe down the road I might start fighting these, and I'd want some legal counsel before I do. But at this point, it's just something I deal with. So let's see. He killed 2 in Illinois. The shooting of the canine happened while the Kenosha police spotted him in a stolen car, and one of the victims in Illinois. So there may be police chase footage in this trial, which would just be cool. Let's see. Can't be lawyers. There's 2 defendants. I think no, that's a lawyer. A lawyer on each side of him is what I see. The charges for DMB says 3 times first-degree recklessly endangered safety, possession of firearm by a state felon, strike police animal, mistreatment of animal, failure to comply with police, and car theft. This might be a good one to follow. What is that pickle brand? I'm going to see if the store got it. Judy, I get mine at Walmart, and it is spicy maple bourbon pickles. Does everyone want to bail on Gwyneth Paltrow? Is that what I'm hearing? This is the camel judge. Yes.
I'm not a camel.
Bay, I don't even know about that one. Okay, so let's do a poll. I don't normally run a poll this way, but I realize the Gwyneth Paltrow case, first of all, it's a civil case, and we sort of lean true crime. If nobody wants to go there, I won't make you watch. What we're watching right now is the beginning of the Wisconsin versus Alan Brown trial. So let's put this up to a poll.
Enter a plea of not guilty, which means the state must prove every element of the offense charged beyond a reasonable doubt. The statutory definition of the crime.
This is like an Elon Musk moment where I put a poll up and I'm not sure if I want the results, but I agree to abide by them. Is that what we're doing? Okay, just 1 second. It has to be. Obviously, it doesn't have to be unanimous, but it's going to have to be convincingly one way or the other for me to switch here. And now it doesn't want to do anything. Why is that? Completely froze. Okay.
I'm not a camel.
Here we go. Okay, the poll is up. I do want to know what you guys think. I think it'll be interesting. We followed Gwyneth Paltrow for almost the whole time, but I've got it's wow, it's close. It's close. He has 2 murder charges in Chicago that are not part of this trial. So this is not going to be a murder trial. It's just basically the cruelty to animal.
Dangerous weapon. Dangerous weapon means any firearm, whether loaded or unloaded. A firearm is a weapon that acts by
Staunch is going to be a tough trial.
Or you may answer this question.
We took the Gwyneth Paltrow trial because we wanted a break. We wanted something that was lighter than some of the trials we had had.
If you are not so satisfied, you must answer the question no.
Stick with Gwyneth.
Count 9. Attempted escape from custody resulting from legal.
All right, I'm going to be closing the poll here in just a little bit. Everyone get your vote in.
Alan M. Brown, on or about Friday, October 29th, 2021, in the village of Bristol, County Kenosha, state of Wisconsin, attempted to intentionally escape from custody, having been lawfully arrested for a crime contrary to section I'm not a camel.
6.42 sub 3A and 939 sub 32 of the Wisconsin statutes.
The state was just faster to try this one, I guess, and maybe he didn't waive speedy trial on this one.
Every element of the offense charge.
Okay. Going to go ahead and close the poll.
I'm not a cat.
We're ending the poll, and it looks like we are staying with Gwyneth Paltrow, 62% to 37%. Sorry for those that were a little disappointed in that. So we will not be going to the animal cruelty trial, which would be a tough one to watch as well. Who said I'm not a camel? I missed it. Kentucky Lake Gal, this judge that's reading the instructions in this trial right now, he's the one we got that soundbite from.
He had formed the intent.
This is the I'm not a camel guy. We use that soundbite. You can trigger it through chat.
Or other extraneous factor. The state's burden of proof.
I'm not a camel.
That's him.
May find the defendant guilty of this offense, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following two elements were present. The elements of the crime the state must prove. Number one, first element of attempted escape from custody requires that the defendant intended.
The only thing I'm really interested in this trial is that if they have just a whole ton of the police pursuit footage that they'll be showing.
Committed by one who
I might go back and watch that.
Escapes from custody when that custody resulted from a legal arrest for a crime.
We're going to go ahead and turn this one down here. We'll switch just to the one we're going to be watching because we said we're going to bail on this one, so I don't want to tease you and then bail out right as it gets interesting. So we're going to go here. This is supposed to be starting any second now. Let's reset that. Don't have any audio coming in yet. The The defense is a crunch for time in this trial. Crunch for time. And they have all these witnesses they're not going to be able to fit in. Thanks, Rockin' Dawkins. I realize a third of you guys are not happy right now, and I apologize for that. Just know that this trial is going to end in 2 days, and the jury will have probably a very quick decision to make. This just gave us a break from some of the heavy stuff we've been following for a while, so we'll see it through. I don't like bailing in the middle of a trial unless we have to. Like the Jensen trial, that was one we had to bail on a little early. Lawyer's head's going to hit the table. It's an early morning for him. He's sleepy, very sleepy. Sarah Boone is going to be fantastic, Susie. We have, speaking of Sarah Boone, we have a hearing for her this week on the 31st, which should tell us if the case is going to go forward April 10th, which is the next big case that we are scheduled to follow. What was the case where the judge, we say camel judge? Yes, that was the Mark Jensen trial, Richard. It was the Mark Jensen. That was the one where he, the antifreeze murder is what we knew that one by. I went back and watched the full 2-hour interrogation of Sarah Boone. She is certified nuts, totally detached from reality. And that's what's going to make that trial just so amazing to watch. Her lawyer trying his best to defend her when she provided the most damning of evidence by filming the crime on her phone and speaking and narrating it. You know, it should be a pretty easy job for the jury. So I predict a very short, is this too early to do this? I predict a very short deliberation for the jury in the Sarah Boone trial, if we ever get that far. I prefer a boring trial, takes my mind off negativity stuff. I hear you, 80s music man. You've been with us through some tough ones, and thank you for that. Annie, welcome back this morning. Good to have you back with us today. Hello to Sweden. And here we go. Almost right on time.
Are the parties ready for the jury? They're all assembled and ready to go.
We're waiting for
Defendants ready?
Yes.
Okay. You can go ahead and bring the jury in.
Okay. Let's see. There's Mrs. Paltrow. I'm not sure what she's drinking. It looks like mud. It looks sort of greenish brownish.
Let the record reflect that counsel are all present, defendants present.
Trying to get the video feed that's higher quality from WTLX pulled up as well. Oh man, Laura, thank you. Let's have a little ASMR this morning with the blue mug.
Mr. Sykes, you're still doing your cross-examination of Mr. Graff. Okay. Mr. Graff in the room?
He's at the hall.
Okay. Could you ask Mr. Graff to come on in? Mr. Graff, could you come and be re-sworn? Good morning.
They re-swear people every day in this trial.
Do you swear that the testimony you are about to give in the case now before the court will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you.
Go ahead and take a seat.
Who did we decide that he looked like?
We're just waiting for the jury.
We are waiting. WLTX hasn't even started their video coverage yet. They're still just a placeholder, so we'll keep an eye on that. B Pattern says, maybe later on consider the other cases after looking into them. Manuel Marin, defendant, and Jared Bredigan, Microsoft executive. I will have to look into those. B, can you text those to the burner phone? Type ! burner in chat and you can text those to me because I'm going to forget in chat. It disappears. I think the judge is having a good time. I think deep down he likes what is happening in his courtroom, even though it's, as Rich says, absolutely frivolous. I think the jury's walking in. Carolyn, thank you for becoming a member. Appreciate you so much. Wonderful to have you here and good to have you in green. Please take your seat on the front row. Reserved seating for you. Just type ! seat in chat. Queen Olive, you're here, but we won't raise
Good morning.
the issue that you were late by
Mr.
an hour.
Graff was just sworn in by the clerk, so he would be ready to go. Mr. Sykes, you may proceed.
Thank you. Mr. Graff, we talked yesterday about, this is Plaintiff's Exhibit 3 and the defense has one. Can you see that in front of you?
I can.
Okay. This is the ski report, instructor's comments, filed by Eric Christensen, correct?
Yes.
Okay. And you reviewed it. You reviewed it?
Yes, I have.
Okay. Now, up top here, can I have the pointer?
This is supposed to be really short. I forget how many minutes he said it was going to take, but this should be a very short cross. 10-minute timer. Eddie, keep an eye on that. Let me know when he goes over.
See, there's a time here, 11:55 a.m.
I see that.
Okay. Can we assume that's a fairly accurate time?
Yes.
And that Whitney Smith, when she picked up Terry Sanderson, marked it as 12:02.
That's when the dispatch came in, was 12:02.
Dispatch, okay, 12:02. Now, you noticed here, name of student. This one has been whited out, but on one that we have, it has Gwyneth Paltrow's name there, correct?
I don't know which one you have.
Well, the one I have has it whited out, but the defense has her name in there.
I see this one that's whited out.
Yeah. And this was a falsehood, correct? The name of the student wasn't Gwyneth Paltrow, was it?
I'm not sure the name of the student.
Well, Eric Christensen's student was Moses Martin. So if he writes name of student Gwyneth Paltrow, that's incorrect, right?
I believe this form is commenting on Gwyneth Paltrow.
Yeah, as a student, but she wasn't his student, right?
I don't believe so.
Okay. Now, would you agree that the crash, the ski crash, was serious enough to warrant someone like Eric Christensen writing a formal report? Correct?
It was serious enough that he made comments about it at the end of the day.
Okay. Is that a yes to my question?
What was your question again?
Serious enough to write a report?
Yes.
Okay, thanks. And you recognize that he claimed here twice that he didn't see it. Right here, I didn't see it. And then a little lower.
Danny's not going to be in court today. She's got a business trip, so she's not there right now. She'll be out.
Did you witness the accident? No. Do you see that?
Yes, I see that.
Now, despite the fact that he didn't see it, and Gwyneth was not his student, he blamed the male skier anyway. Correct?
Are you allowed to chew gum in court? Is that, I mean, just in the gallery? Does anybody know?
He blamed the male skier for the crash, correct? Now, did that bother you?
Is there a question?
Yeah, there was. He blamed the male.
You allowed the
It's a very simple question. Okay. He blamed the male skier.
Can you answer the question?
He said,
Yes.
I didn't hear
Thank you.
the question.
Yes, you
Well,
can
that
answer, or
wasn't
yes,
yes
he
to the
blamed the male
question.
skier.
It was yes to the judge question. I can answer your question. I'm just reading before
Okay.
I answer the question.
Just read additional comments there.
I did. I don't know that I see blame there.
First thing male skier stated was that she appeared right in front of him, thus admitting he was the uphill skier. She
Right.
never saw him because he came in from behind. Now, you don't consider that to be a blame?
I consider that to be just what it says, that thus admitting he was the uphill skier.
Okay. Did it bother you that now at the time you were in charge of all ski instructors, weren't you?
No.
What was your title?
I was the ski patrol manager.
Ski patrol manager.
Correct.
Okay. Ski patrol manager. Did it bother you that a Deer Valley employee, an instructor, whose report you read, blamed the male skier even though he didn't see it? Did that bother you at all at the time?
I don't see blame here. I
Okay.
just see thus admitting that he was the uphill skier.
Now, did it bother you, Mr. Graff, that on this report, he never got the male skier's contact information?
No.
Now, you're sitting there a day or two later, you testified about it, and you read this report, and there's a crash that was serious enough to haul someone down off the mountain on a toboggan. And this man who's writing this report never gets the male skier's contact information. That didn't bother you?
That didn't bother me.
Did it bother you that Mr. Christensen never gave Gwyneth Paltrow's contact information? That bother you?
That didn't bother me.
Did it bother you that Mr. Christensen never gave his contact information to anybody?
None of these bothered me because at the time everybody skied away with the assumption that everyone was fine.
Okay, so your understanding was that everyone skied away, even though a ski patrol person named Whitney Smith hauled Terry Sanderson off the mountain in a toboggan, and in your definition, that's everyone skiing away because they're all fine. Correct?
Whitney Smith responded to Mr. Sanderson in a different location from where the collision occurred.
There's no poll right now,
So they
Karen.
all skied away.
Sorry.
Now, let me ask you this.
Oh my goodness. She's going to get called out.
This claims here that a man with 4 documented broken ribs, 2 of which were separated, broken, not just cracked, but separated. 4 documented broken ribs, said he was okay to 2 other ski patrollers that allegedly came by. Did that bother you at all?
That's my understanding of what happened.
Did it bother you that allegedly, is this yellow over here? But a patroller came by to check on everyone. Did it bother you that there was no log of that patroller?
No.
Didn't bother you. Okay. So nothing so far has bothered you, right? Okay.
These are just the facts.
Everyday life at Deer Valley, right?
Facts don't bother me.
Yeah.
Okay.
It's pretty chill.
Now,
Mr. Sykes
bother you?
walks up to the jury like this and does hand motions. And Danny said yesterday 2 of the jury members were laughing, almost had to contain themselves as he's doing the Papa Bear walk up to the jury approach. So they're not buying the theatrics apparently.
You see this right here where my cursor is?
Yes.
that Eric Christensen, after this crash, goes to lunch with one of the most famous actresses in the world and her family. Did that bother you at all?
No, I think that's standard practice for ski instructors.
Did it bother you that 3 hours after lunch or so, that he then writes his report? That bother you? Did that concern you at all?
No, that's typical of what happens.
Did it ever occur to you that this instructor might be covering up bad conduct by himself to protect Miss Paltrow, a big spender at Deer Valley? Did that ever concern you or bother you?
No.
Did it ever concern you or bother you that he might be covering up bad conduct by Gwyneth Paltrow?
No.
Didn't you basically wink and a nod at this bad conduct? Wink and a nod at it.
Can you define that?
Do you know what wink and a nod means?
No. That's why he's asking, could you
Well,
define
actually, you did, because we had a deposition on another case. But wink and a nod, as I'm using it, means you see something wrong, but you just wink at it and go on and don't do anything about it. Isn't that what you did here today?
Absolutely not.
Okay. Why wasn't this instructor terminated for filing a false report?
This is his report. There's nothing in it that's false.
Isn't it true that you believe he wasn't fired because he did nothing wrong? He did nothing wrong.
Correct.
Okay? And there was no cover-up by Deer Valley, correct?
Absolutely not.
Thank you. No further questions. Thank you.
Wow. 10 minutes.
Thank you, Mr. Sykes.
10 minutes. Time's up. It was close. I think it was a tiny bit over.
I just have one question, Your Honor.
He's got his dongle attached to the iPad. We're just looking for an HDMI cable right now. Let's see. There's a cable. Oop,
Good
short
to see
cable.
you again, Mr. Graff. Thank you for coming back.
Thank you.
Very nice of you. It's okay. I was cooperating yesterday. I think I just need to go back to the old technology again. Okay, so I just want to ask you, Mr. Graff, one question.
Excuse me 1 second. I've got my computer.
Oh, yeah, go ahead. I just want to ask you, Mr. Graff, a quick question about the patrol log. Published this, we looked at it yesterday with you, Defendant's Exhibit 26A. You were asked questions, not today, but before you left the stand yesterday by Plaintiff's counsel about this bad boot entry here. Do you see that?
I do see that.
And do you remember questions about how that was sort of a minor issue, and he was asking why that would be logged, but other major issues might not be?
Yes.
So can you explain what is a bad boot, and what would it require of a patroller who came upon that kind of a problem?
You know, I'm not exactly sure what this bad boot issue was, but it could be that a buckle was broken. It could be that, as funny as it sounds, could be they were on the wrong feet. You know, you see things like that. So there was some issue that Jess responded to, and it was as simple as a bad boot.
And might it require a toboggan down the hill if someone had a malfunction that they couldn't get down the hill?
Yes.
Okay, so
a little bit leading.
And then this section here, 1202. Again, I'll use this little laser pointer. 1202 here. It over in the nature of the injury discussion, it says skier collision and disorientation. Do you know who wrote that?
I don't know who wrote it. Whoever is manning the dispatch is the person who puts these entries in.
Okay, so would it be fair to say then that it would not be Whitney Smith that wrote that?
It would not be Whitney Smith. They're transcribing what Whitney Smith is saying over the radio. So Whitney Smith was on scene 2 minutes after the call came in, and then whoever was there wrote down what she said.
Okay.
And she said that she was on scene of a skier collision with the patient experiencing disorientation.
Right, and the jury has heard what her experience was, and you don't know anything further then you've already told us about that, correct?
That's correct.
Okay, thank you.
No further questions.
According to
All right,
Danny,
you are excused. Thank you.
on direct.
Is there a possibility the witness may be called back?
The
Not from us.
Yeah, very small.
Okay. So you're still
Very
under,
small possibility.
I guess, this trial, so please don't discuss the case with any of the other witnesses. Thank you.
According to Danny on direct, as I was listening to her last night on her live stream, she was in the courtroom yesterday, and she was saying she sat next to the gentleman in the orange shirt, and
Mr.
they're
Holmes,
friendly.
is your next witness ready?
But she was describing how
Yes.
the
Our
space
next
in that
witness
courtroom
is Dr. Scher.
is
People
are fighting
need
over
an
spots.
easel and to set up for him to draw, and we may need a second to do that.
Okay.
Okay.
Go ahead and set up.
Okay, so they're setting up as they get that going. So people are sort of you can't save spots in court.
Dr. Scher?
But the CBS person
Good morning.
did.
Come on forward here and be
Had
sworn
her
in as a
coat
witness.
spread out over the bench, and Danny had to move
Do you
it.
swear
it was
that the
fun to hear
testimony you are about to give in the
back and
case
forth.
now before the court will be the truth, the whole truth, and nothing but the truth, so help you God? I do. Thank you.
And then take a seat here and adjust your microphone, and then
This doctor
please
looks really
state your
happy to
full
be here.
name and spell it all out for us.
I wonder if it's still a broken chair.
Thank you.
Yep, I think it's broken.
My name is Irving Scher, I-R-V-I-N-G. Last name is S-C-H-E-R.
S-C-H-E-R.
Thank you for being with us
Somebody
here
grab
today,
that for
Dr. Scher. Let's begin by just asking you what you understand your role here to be today.
To teach the jury about biomechanical engineering related to snow sports, and particular skiing.
And do you have an understanding of what Plaintiff's biomechanical expert, Dr. Boehm, has said about this case?
I have. I've read his deposition testimony and his trial testimony, so I do understand what he's saying in the case, yes.
Okay, and you have opinions about his testimony, is that right?
That is correct. I've analyzed his biomechanical engineering analysis.
So the jury will get to hear your response to his analysis?
Exactly.
Okay, great. So before we get to that, let's talk about your background and training so they understand why you and not me are on the stand.
Sure.
Where did you go to school?
I did my Bachelor's of Science and Engineering at the University of Pennsylvania. I majored in mechanical engineering and applied mechanics. And then after undergrad, I moved west, and I got my master's and my PhD at UC Berkeley in the mechanical engineering department. And I had two disciplines that I specialized in. One was called dynamic systems. That's how objects move in space when forces are applied to them. And the other is biomechanical engineering. And that is the application of physics and engineering to the human body, in particular looking at how people get injured and how to prevent injuries.
So many buttery smooth voices in this trial.
Did you do a PhD thesis?
I did.
And can you explain what you worked on?
Sure. I was the last in a line of what we called skiologists. I studied the biomechanics of alpine skiing. I created load cells, so those are devices that measure the forces, and I put them in between the skis and the bindings. And I had different instrumentation on skiers, and it was the first time, or at least that I'm aware of, that anyone in the scientific community was able to measure the forces and the body motions of skiers from the top of the mountain all the way down to the bottom. And I did this with beginners, people who had only skied 2 or 3 days in their whole life, all the way up to professional racers. And so that's what I got my PhD in.
And this is actually measurements on the slope as people are skiing.
That's right, exactly. Yeah, I'm measuring the forces applied to the person and their body motions as they're skiing. Well, and falling. We did have falls as well.
Right, and so this is not just calculations in some ivory tower, but you're actually out in the field looking at
hands-on work, which is quite difficult when you have electronics and snow and water. It was challenging for sure.
And do you also do any teaching?
I did teach. After I graduated with my PhD, I did a small postdoc in the biology department at Berkeley. And then after that, while I was working for a company, I taught at the University of Southern California. I was in the physical therapy department on the medical campus, and I taught Intro to Biomechanics, and I also did research there at USC. And then I moved. I now live in Seattle, and I'm at the University of Washington. I have an affiliate professorship there. I'm an associate.
If you need to talk,
associate
call
professor
on the okay?
at the University of Washington, and I occasionally lecture, but mostly advise grad students.
What about professional licenses? Do you have any of those?
I'm a registered professional mechanical engineer in California, Washington, and Alaska.
And then in terms of professional societies, these groups of people that get together to research and work on a certain field, are you connected to any such organizations?
I am.
And what are those?
I am chair of a group called ASTM F27. If you've ever gone to a ski shop and purchased ski equipment or rented ski equipment and they set your bindings, what some people call DIN settings, that's based on the standards from ASTM, and I'm the chairman of that group. We also do other snow sports equipment. I represent the U.S. for snow sports equipment safety at the International Standards Organization, so the ISO. So if you go over to Europe, you'll have the same release and retention
These are some
settings
legit
for your skis.
guys.
Your bindings won't pull off your skis. They use the same standards that we've developed here in the U.S. I'm also president of a group called the International Society for Snow Sports Safety, and that's more academic than the other two organizations I was mentioning.
He's like the president of every organization.
We call it ISSS. ISSS is the premier organization worldwide to present and publish your snow sports safety research. And we have members from all over the world: Switzerland, Korea, Norway, obviously the US, Canada, Australia, New Zealand. It's quite a great group, and it's really the group that helped develop ski binding standards.
So you do some research on the safety of snow sports like skiing, correct?
That is my main focus of my research ever since grad school, and I've continued to do that now.
And then you also evaluate cases in a litigation context, is that right?
I do. About 15%, 20% of my work is forensic work. The rest is research and development.
So most of the time, are you doing research to try and improve the safety of skiers on the hill?
Yes, and I should say it's not just snow sports. I work in other recreational sports areas, water sports, mountain biking, other areas too, but snow sports is my favorite, my passion.
So let's explain to the jury what biomechanical engineering is, just because we could use a refresher.
Sure. Biomechanical engineering is the application of physics and mechanical engineering to the human body, but in a forensic sense, it's what links the event to the injury. So if you have some type of event and there's forces and motions in the event, in the accident, the forces are applied to a person, there's internal forces on their, like in their body at the joints or something like that. The amount of force and the amount of motion it takes to create damage to the body, that is biomechanical engineering.
And how's that different than medicine? They're both dealing with the human body, but what's the difference?
Sure. The medical field tends to take the injured person, figure out what's wrong with them, so diagnosis, and then try to get them better, so treatment with an eventual outcome. So most medical training is after the injury, as opposed to what forces and motions create the injury. We like to think of ourselves on different sides of the injury.
Thank you. Can biomechanical engineers determine the forces required to produce fractures of bones in the body?
Yes, there's a lot of research on that, and that's one of the main areas for biomechanical engineering.
So is there scientific literature that describes the forces needed for, say, rib fractures?
There is, yes.
And you're familiar with that literature?
I am, yes.
And let's maybe ask a specific question about that literature. given your knowledge of it, does a 70-year-old man need to fall on his side with his elbow between him and the ground to cause rib fractures?
No. So there have been a number of scientific studies, mostly done by biomechanical engineers, but there's other scientists who have looked at this as well. And what they do is they take cadavers or portions of cadavers and they apply forces to them. Sometimes they'll swing a pendulum into the side of a cadaver or to the front, or they'll have a plate, a very heavy-weighted plate, contact the person arm down, arm up at 45 degrees, or they'll drop the cadaver in different configurations, and then they'll see what injuries are produced. And so when they've done this, in particular for chest impacts, what we find is you can get lateral rib fractures, according to the biomechanical engineering literature. You can get lateral rib fractures with an impact to the side with your arm down or with your arm up. But you can also get lateral rib fractures from compression, so front to back compression of the chest. So if I press my chest in like this, what happens is the ribs actually bend out on the side, and that can create fractures on the side, and that's quite common as well. So rib fractures are not just from side contact, it can be from front to back compression as well.
So let's get to what you did in this case. So what did I ask you to do in this case?
Basically, you asked me to evaluate Dr. Boehm's biomechanical engineering analysis to see if it was accurate and correct.
And what material did you review? I think you already mentioned you read his transcript and you watched his trial testimony. Is that right?
I did, yes.
And maybe for the jury, in case they need a reminder, he had that green screen in the back of him.
Right, just the talking head.
Exactly. Speaking from Florida, I think.
That's right.
Right. And so let's just start with his analysis. Do you agree with it?
I do not. I do not agree with his analysis.
And maybe before we explain why, just give us a sense of what you understand his method and analysis to be.
Sure. As I've gone through what he testified to in his deposition and the trial, looking at his calculations and what he's done, to me, there's two parts to his analysis. The first is calculations to show that Ms. Paltrow had to land on Mr. Sanderson in order to get the rib fractures that he got. And then there was a second part that basically said because Ms. Paltrow had to land on Mr. Sanderson, that could only happen with Ms. Paltrow hitting him from behind. It couldn't happen any other way. It was impossible. So that's my understanding of the kind of the two parts, the main parts.
Thank you. We'll go over those in more detail. As you looked at his analysis, you read everything that he read, correct?
I did.
And did you read even more than that?
I had additional depositions, that's correct.
Of the various people that were at the scene of the accident?
That's right.
So let's get one thing out of the way. Do you agree with Dr. Boehm that Mr. Sanderson's rib fractures did not occur during the initial skier-to-skier contact?
Yes, I think that's correct. There's no disagreement at this point, at least from the testimony I've heard. The skier-skier portion where they first contact, no matter which version we have, did not create the rib fractures. I don't think anyone thinks that at this point, so that's good. We agree.
And in terms of just a quick overview before we go into his calculations, which you can explain to the jury, do you believe that Ms. Paltrow's account, and I should say, are you familiar with her account?
I am.
And you heard her trial testimony?
I did.
And read her deposition. And
yes.
do you believe her account of the collision is consistent with what you know about biomechanical engineering?
Object. Goes beyond the scope of this expert witness.
And calls for him to evaluate.
What goes your testimony? Would you please approach the bench?
First sidebar. We're going to count the sidebars today since that was brought up yesterday. So if we can have a volunteer, can't be Crusoe. Crusoe's taking care of the internet, but somebody else in chat who's committed to be here and pay attention. If you can count the sidebars, this is number 1. And you might also want to note that the objection was, if you want to count objections, this objection was from the plaintiff on this one. Sidebar on the bingo card. Your comments are great today. Just a reminder, we do try to keep this non-political. Our slogan is pickles, not politics. I realize there's some serious issues out there, especially in the news today in the last couple of days that are pretty heavy. We'd ask that some of those are not a good fit for this medium. It's hard to have strong, discussions about issues that we have strong opinions on back and forth in chat where it's limited to 200 characters and we can't sense sarcasm very well and things like that. So we'd ask that we try to keep it focused on this trial today. I appreciate you guys doing that. This witness literally majored in just all the fun stuff. Everything you want to do instead of studying when you're in college. You want to go mountain biking and hiking and snow sports and things like that. He's like, I've got an idea. That's going to be my major. And so I'm really just studying when I'm out here on the mountain.
Okay, so let's go back to that question. I was asking you, in your opinion, is Ms. Paltrow's account consistent with what you know about biomechanical engineering?
Yes, it is.
And maybe another way to put that is it consistent with the laws of physics?
It's the same question, yes.
Yeah, and
exactly.
Dr. Boehm, the jury heard, talked a lot about Newton's laws and the laws of physics, applying those to the evidence in this case. And again, in your analysis, as you apply them, Ms. Paltrow's account is consistent with those.
Objection, Lex Foundation.
Objection number 2 from.
That's correct. Ms. Paltrow's version, her scenario is consistent with the laws of physics and what we know about biomechanics.
And then the account that Dr. Boehm gave, and that is based on Mr. Ramon's account, is that consistent with the laws of physics?
I do not believe it is, and I can explain as we get into it.
Yes. Okay. Great. We'll explain that. Let's go to Dr. Boehm's calculations so you can explain to the jury your analysis of those. We have an easel, and as I understand it, you would like to kind of draw so that you can show them what the equations mean. Is that correct?
That's exactly right.
Okay, so I'll grab the easel and then that board.
Ooh, zipper ASMR. I like it.
We can't block the judge. Judge, where do you want this easel?
On the screen? He's going to also need to see the screen, so is it okay if we put it
Can the
right
jury
here?
see
Are
it?
you going to be able to see that?
I can't see it, but it's really more important that the jury see it, so I'm fine with that.
Okay. And I think if it's okay with the judge, you can get off the stand and,
Yes, sure.
And there's your marker.
Okay, audio's going to be rough here because he's not mic'd, so I'll try to play with it as much as I can.
Okay, so I'm going to pull up something that Dr. Boehm pulled up in his deposition. Do you remember seeing these documents? And for the record and for counsel, these are the notes in Exhibit 3 of Dr. Boehm's deposition. Oh, thank you.
He's got a solo here.
I missed the question there.
Yep, no, you're fine. So I'm just pointing you to...
Before you, these are not admitted exhibits, though.
Yeah, I'm not asking them to be admitted. They were just shown in Dr. Boehm's deposition, so we're showing them here as well.
Okay, but not in his trial testimony.
He's responding to these.
You said deposition.
He also showed it in his trial testimony.
So trial deposition.
I was going to say direct things to the judge, but
I recall this being flashed
Withdrawn.
during his deposition or during his trial testimony.
Okay, thank you, Dr. Schur. So you recognize this page?
I do.
And I was just describing it. This was shown in Dr. Boehm's trial testimony, correct?
That's correct.
And he explained that these are his calculations.
That's right.
Okay, and there's another page as well. I think it's the one just before it, correct?
That's correct. This is where he starts the calculations for the ribs. We're concentrating on the ribs here because that's what he says determines how the accident happened. He said the head injury doesn't matter for that. It's only the ribs.
Okay, great. So since I have very little idea what's going on there and you do, maybe explain to the jury what's going on.
Sure. Can we go to the page before this?
Sure. And maybe if you, it's just a little bit hard to hear.
Sorry, is that better?
Yeah, that's
okay.
a little better. Yeah, thanks.
So he's using some basic equations for what we call the center of mass to figure out what happens when someone falls to the ground. Center of mass is if you were to balance someone on your finger, the point that you'd hold them at so that they stay balanced. It's usually a little bit below your belly button, kind of midline front to back, midline left to right. And so if you took all the person's weight, all their person's mass, and put it into one point, that would be the point that you're interested in. So that's what Dr. Boehm is doing in these calculations, is he's using that point for Mr. Sanderson. And this first part here, where he has this, that's an equation, X is position. So he's saying there's a certain distance that center of mass falls, and you can see that over here. That's 3.5 feet, or he does it in meters, 1.0668 meters. So center of mass falls to the ground. He's saying that there's no initial falling position, that's fine. No initial falling velocity, V is velocity. And then he has 1/2 acceleration times time squared. And that equation is correct. Acceleration here is the acceleration from gravity. So what he's saying is Mr. Sanderson's fall to the ground for the center of mass from 3.5 feet, which is probably about right, hits the ground within, and he calculates the time, he solves for time, 0.466 seconds. So that's the first part of that, which is great. The problem comes in that he then says the velocity at contact is 1/2 acceleration times time. And that is absolutely wrong. That is not the velocity at contact. The velocity at contact,
you guys should be taking
is
notes.
just the acceleration times time. So he has this extra half. And it was unclear to me why that would be there to start, and I'm not sure why he put that in. But it creates problems for his calculations and his opinions moving forward. If we can go to the next page, I can explain that. So these are his equations. If you remember in his testimony, he said 4,000 newtons. And that's an engineering unit in metric for force. 4,000 newtons is roughly 950 pounds, I think, in English, but newtons is fine. Over 4,000 newtons, you get the rib fractures. So what is this equation here? I'll show you that and then explain why that 1/2 makes a big difference. So that equation there comes from, at first, kinetic energy. We label that as KE, which is equal to 1/2 mass times velocity squared for that center of mass. And then he's saying, okay, Mr. Sanderson, as he hits the ground, has a certain kinetic energy. That energy has to go somewhere. So what happens is a force is applied from the ground to his center of mass, and he decelerates over some distance. So you can see here he has 3 inches written here. That's important. So this kinetic energy has to be taken up by some force over a distance. That's some amount of work, and that will equal the kinetic energy. And then he divides both sides to get the force.
At this point, he's going to call one of the jurors up to finish the equation.
So the force on Mr. Sanderson is 1/2 mass times velocity squared divided by distance. And that's exactly what we have here. We have 1/2 mass, velocity squared, and distance. Now, remember, he's doing this in metric. So that 136, that is in kilograms. That's equal to about 300 pounds. So here he has Ms. Paltrow and Mr. Sanderson's mass put together. So in this fall, he's saying, okay, the kinetic energy of both of them is needed here during contact. But can we go back to page 5? He uses the velocity here, the 2.29, that has the 1/2 in this. So if we go to the next page, yeah. So you can see he's using the wrong velocity. What happens is if you use the wrong velocity in here, let's do BAMES as, call this wrong. So what you get is 1/2 mass times 1/2 acceleration times time, oops, squared, there we go, divided by distance, and squared there. Correct is 1/2 mass
the fact that he's doing this from
acceleration times time squared. So that 1/2 goes into this equation. What does that mean? That means that this half gets squared. It becomes 1/4. So the force that Dr. Boehm calculated for this landing was actually 1/4 of the force he should have calculated. He was off by a factor of 4. So it shouldn't be 4,680 newtons. It should be 18,600 and some newtons. Actually, I have it here. 18,678 newtons. So he's off by quite a bit.
And if I may, Dr. Scher, what this is obviously all at least new to me and maybe new to some jurors. What in the end is the takeaway there if there's that much of a mistake?
So there's two things. One is if there were 18,000 newtons applied to Mr. Sanderson's chest, we would expect much worse injuries. The biomechanical engineering literature for much less than that has many more rib fractures, internal injuries, all sorts of things. We don't see any of that for Mr. Sanderson. But the real takeaway and the importance in this case is the mass here. So because he does the 1/4, he needs the mass. He needs the mass to be 136 kilograms. Now, if you redo the calculations correctly with just Mr. Sanderson's mass, so Mr. Sanderson is about 80.5 kilograms, or roughly 177 pounds, at least according to the medical records. If you do the calculations with the correct equations and only his mass, you get over 4,000 newtons when he lands. Actually, you get 11,056 newtons. So if you were to fall to the snow using Dr. Boehm's calculation method the correct way, then just Mr. Sanderson falling, not Ms. Paltrow involved at all, he could get rib fractures. This is not quite correct overall. Normally we use what's called effective mass, so all of Mr. Sanderson's mass wouldn't go through his chest. Maybe there'd be some force on his legs. If he hit his head, some force on his head. We typically would say maybe 50% of his mass would be appropriate for effective mass. So instead of the 80 kilograms, we would do, and actually I should put over here, this winds up being 11,000 newtons. And if we do the 40 kilograms instead for Mr. Sanderson, so, and that's, and we use the correct equation, we get sorry, I don't do the math in my head, 5,500 newtons, approximately. What this means is Mr. Sanderson can fall to the ground without Ms. Paltrow landing on him and sustain the rib fractures according to Dr. Boehm's calculation method. So if done correctly, he cannot say his opinion that Ms. Paltrow had to land on Mr. Sanderson to get the rib fractures, which means that this goes through the rest of his analysis. So the rest of his analysis is wrong. So this is really critical, that 1/2 that he did for the velocity, the wrong velocity, really threw the rest of his analysis into question.
So, Dr. Scher, there's a lot more we could say about the calculations, I'm sure, and you would approach it differently than he did, correct?
That's correct.
But given the way he did it, if he did it correctly, you're saying that the conclusions that he came to are inconsistent with his opinion?
That's correct. Yes, okay. Exactly.
Okay, so, yeah. Okay, Doctor.
So that
let's
discredits
talk about,
the witness quite thoroughly.
Let's talk about skier collisions. You've, as you explained earlier, done research to understand what forces are like on the ski slope. In this case, how would you apply what you know about physics to understand the claims about the ski collision?
Sure. I would apply Newton's laws to the contacts, the different versions of the events, and see what makes sense, how it would unfold. Do the physics of the contact that's being testified to make sense? Is it self-consistent?
And this may be another opportunity to draw some pictures if you need to, so feel free to if it will help you. But you were talking about the center of mass earlier. How does that concept factor into how you would evaluate the evidence in this case?
Sure. Yeah, if it's okay to draw again.
You may.
Thank you.
And I can see what you're drawing through the monitor here. So.
Oh, nice. Perfect.
Great. And if you need more board or pages, we have them now. Is that correct?
That is a big whiteboard.
I think we're okay with distance, right?
Okay, yeah, great. Go ahead.
So the thing to know with Newton's laws, force equals mass times acceleration, if you have some, and I'm going to draw two versions of a skier, and I'm not the best Pictionary player. I'm going to draw a top-down version, and I'll draw a side version. So let's start with the top-down. So if we have a skier, and here's the skier's head, and here's the skier's nose, and then we have two skis.
I'm with him. I get this. Stick figures.
The center of mass would be,
egg
as we
on a
mentioned,
chopstick.
looking down, somewhere around here. Now, if you have a force that goes through the center of mass, so let's say the force goes through, then the person will accelerate in this direction. They'll accelerate along the line of the force. But what happens when you have a force that doesn't go through the center of mass, it'll create an acceleration going in that same direction, but it'll also, there's a distance here, it'll also create a torque, which is equal to the force times the distance, that will cause the person to rotate. And that's really important because if the force does not go through the center of mass, there's always a rotation. So if you're hit on this looking down, this would be the right side, then the person's going to rotate counterclockwise in this image. The same thing is true if we look at a skier from the side. So if here we have our skier, and here's their pelvis and center of mass. It's our ski boot. And if the person, for example, has a force applied below their center of mass, then there's, again, some distance. That's going to create a torque and a backward rotation so that the person moves backward and falls back. there's two things to note with this for skiing in particular that's different than most other events. Skis have releasable bindings. So if I'm looking at this side view, the boot is held in by a heel piece and a toe piece. And so if you have someone pitching forward, if the ski slows and the person's center of mass moves forward, it'll create a torque on the boot and it'll release the heel of the boot. And for someone of Miss Paltrow's size, that could be anywhere from, well, it's approximately 143 foot-pounds, so 143 pounds acting over a foot. Same thing is true for the top-down view. If we look at the toe piece for the binding, if there's a torque on the ski, a twisting torque, the ski will also release from the boot. And for someone of Miss Paltrow's size, it's about 37 foot-pounds. So in front of the boot, if there's 37 pounds 1 foot ahead, it'll release. If it's 2 feet ahead, it's half that value, so roughly 17. So these are the principles that we need to understand the mechanics of an impact.
Try not to comment on the drawing.
So when we apply those principles to this case, what conclusions do you draw?
Sure. The first is that Miss Paltrow's version of events is consistent with the laws of physics and how people move and rotate.
And what about Mr. Ramon's version?
For Mr. Ramon's version, I couldn't get it to work. It doesn't match with the laws of physics. The complete part of his testimony just doesn't fit.
And so can you explain why it doesn't fit?
Sure. So Mr. Ramon's version, maybe I should sit down.
Oh, sure. Yeah. Go ahead.
Okay, we need to re-edit this. Him drawing that picture with different audio,
so
different
in
description
Mr.
of what he's
Ramon's
drawing.
version, he says that he sees Miss Paltrow contact Mr. Sanderson squarely in the back, and he says that it's in the middle. It couldn't be any more in the middle than if he tried, or if she tried. And then also that she rode him down. I think the quote was something like, in his deposition, he says, like she couldn't have been on his back any more than if he had strapped her to his back, something like that. So as they're going down in Mr. Ramon's version, Mr. Sanderson goes spread eagle, arms out, legs out, and the key for me is that Mr. Ramon says that the inside edges of those skis that are going into this V catch, and Mr. Sanderson stops on a dime. And if that were the case, then Miss Paltrow would keep moving, and, well, maybe I should draw.
Sure, go ahead.
Yes, please, please draw. I need you to be the court artist, drawing the rest of the case for us. Everything that happens should be depicted on the whiteboard with this guy drawing.
I'm going to try to draw a top-down version of this. So if we have Mr. Sanderson, and here are his skis.
The PhD drawing a stick figure is priceless just on its own.
This is a different color
so good.
for Miss Paltrow. How about blue?
Oh. We're branching
Miss
out.
Paltrow contacts him from the back, and now this is the same whether one ski is between his or both skis. If the skis are apart, it's a little bit different, so we can get to that in a minute. But if her skis are between his, let's just say, then when he falls, and here is his, so they're moving in this direction. That was probably obvious, but I wanted to make sure that was clear. So now we're still looking down. Here's Mr. Sanderson's back.
Obvious.
Here's his head. Here's one arm. Here's another arm. Here's one leg, the other leg. Now, remember, Mr. Ramon says that his skis are in a V, spread eagle. So now if that were to happen, then he stops very quickly, and Miss Paltrow
could draw this.
is going to remain
I don't have a 3-year-old.
in contact somewhere around here, and her skis are going to stay underneath Mr. Sanderson. When that happens, it's like the center of mass continuing to move forward while the skis slow rapidly, which creates an upward force at that heel. It's going to create a heel release. But as you heard in the testimony, all the skis were on. It doesn't work. It takes actually very little force for this to release, the heel piece to release, in a scenario like this. So it doesn't match with physics. And it's the same way whether one ski or both skis are in between.
Okay, so how do you know this, especially about the bindings releasing? How are you confident about that?
My experience, I mean, I've seen tons of binding releases. I know how bindings work. It's just physics.
Right, and you've specifically done research on binding releasing?
Oh, yes.
And you said earlier that there were other scenarios, the skis maybe between Mr. Sanderson's skis, maybe they're diagonal. Did you do evaluation of all those sort of scenarios, and did any of those work?
No, I couldn't get any of them to work. So the key is either she would come out of the bindings or she would be stuck on Mr. Sanderson. She wouldn't be able to move past him. If her skis stayed on in various versions of this, I don't know how she continues to move downhill the 10 feet that Mr. Ramon said she wound up if her skis are trapped underneath him.
And would you expect her to get an injury in any of these scenarios?
Well, certainly there's that potential, yes, a lower extremity injury for sure.
If, for example, her legs get stuck in one of the scenarios you mentioned.
Right. So, for example, if her ski is rotated out to the side going in that V with one of his skis, the other, whether it's on the outside or in the inside, can't wind up. So if her ski is on the outside, his ski is going to push her ski out. If this is her ski, as he's falling and moving into that V configuration, it's going to go from this position to here, and it's going to push her ski outward, which I would expect would create a toe release, a twisting release of the bindings, because it actually takes about 18 pounds of force, between 15 and 20, depending on how her bindings would be set. So very little force to release that toe piece. But even if it didn't release, then her ski winds up getting trapped by his, and she can't move forward. So, and in many of these scenarios, her leg would get twisted in a really odd way that would likely create injuries.
Okay, great. I think you can sit down again. And now what I'd like to do is ask you about whether you were involved in creating any animations that would help the jury understand your opinions in this case.
Oh, please.
Yes.
Tell me, Drew.
And, Your Honor, if I may ask for permission to show the witness these animations so that I can lay some foundation, he can use them to teach the jury.
Yeah, we reserve our same objections on these animations, Your Honor.
Understood.
Okay, so it sounds like he made these computer animations we saw the other day. We'll probably get all 7 admitted through this doctor, is my guess, or at least the rest of the 7 that we have not seen here, as well as the actual impact moment, because he's an expert.
It's been plugged in, but it's now...
It's dead. Battery's dead. Who had dead battery on their bingo card?
Why don't we take a recess while they straighten out the technology, and then we'll be back.
We get a quick break. That artwork should definitely be auctioned off. I think probably Deer Valley would want to buy it and post that on the wall somewhere in the lodge. I think that'd be great. Yes. Les Worthington had dead battery.
Step down.
Good job.
Whatever you need to do. Thank you.
Do what you need to do. Is the attorney's name Clark Kent? We call him that, but that's not his name. I don't remember his actual name. Michelle said, "I'd love to cross." You know that Cross is gonna poke fun at his stick figure drawings. Okay, they're gonna poke fun. Although he drew it. It was simple. It's very simple. It was like third grade simple, but it made sense how he was describing it. It was the jury could probably follow, as opposed to the equation where he was, in his element. The jury probably didn't follow the equation very well and probably understood the results, the outcome, but they probably weren't beating him to the conclusion as far as what the totals were and what the numbers were. But I don't know. There might be a math whiz in there that's just like, yeah, this is my jam. Let's see, coming from our cabin in the middle of nowhere. Awesome. Glad you two made the connection. That's awesome. Good to have you here. Stay safe and warm. I do believe I saw an apple at an angle. Okay, so I think he has a cover on his computer. I don't think that's the actual, like, straight from the factory top of the computer. Apple does have a logo. A lot of PCs, as well, have a logo on there that appears. I think he has some sort of a protective cover on there, so it's sort of concealing the brand. Apple, maybe Apple. PhD in Ski Rex, but can't charge a computer. It's actually the lawyer's computer. It's Clark Kent's computer that did not charge. On this cross, they're going to poke fun at the drawings. They're going to, especially because they were mocking the other expert that he's the counter to. I think it was Dr. Boehm was his name. The green screen guy, floating head. They're making fun of, ha, 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 he's got a green screen. Then he comes out and draws Pictionary for kids. Like kindergarten version of Pictionary with his computational fluid dynamics, as Jeanette French says. It's funny. So there's going to be some jabs back and forth. I'm surprised. I'm sort of not at the same time that there have not been a lot of objections about what he's presenting. I think there is nobody on the plaintiff side as far as attorneys go that can argue with the numbers and the formulas. They're out of their realm there. So they'll have to call up another expert to maybe do some rebuttal. Do not believe he was unconscious. He never mentioned that to anyone that day, says Laura. This is why he can't take his jacket off, because he would see that Superman shirt. Hey, Brett, welcome. Good to have you here. Let me know if there's a question or something. I see you got my attention. We're talking about the computer. The computer. Together in the UK. Big hello from both of us. Danny, awesome. Good to have you both there. Watching at the same time on the same device, I assume. I would love to see this guy's calculation diagrams on ski slope zorbing. Zorbing, for those that don't know, I believe is when you climb into one of those big inflatable sort of bubbles that sort of protect you in an inner bubble, and then you get rolled down the hill. It's usually a summertime sport, and oftentimes there's some water on the inside of the bubble, like the inner bubble that you're in. There's water to allow you to slide, so it's like a slip and slide for you on the inside instead of just making you completely dizzy and nauseous, because that doesn't end well for anyone. But ski slope zorbing is quite the thing. It's like being protected by a giant airbag that's clear that you can see out of as you go rolling down the hill and have zero control. Stick figure drawing should be the new Deer Valley logo. They lose that deer profile and go with the stick figure collision drawing, I think. Very effective illustration, says Puppy Dog Sherpa Bone Digger. Yes, how much these experts are charging. That's going to come in the cross. And if they ask a question, just to jab, because if Sykes is doing it, they're going to ask a question about, do you charge extra for your drawings or something like that? It would be gold. I cannot wait. It's going to be so good. Let's see. Using calculations to quantify the crash, especially when citing an injury, will not be in a doctor, is a giant insane stretch, says Jim Bob. This guy, apparently, he did all the math. He's studied, everything from the U.S. ski team down with actual measuring devices on skiers from all different ages and sizes and levels of expertise. Let's see. Do I agree with this expert? Puppy Dog, I'm way out of my realm when he talks about math. I'm going to have to defer to someone else to be able to understand that. The way he explained it, it seemed to make sense, but I imagine another expert could explain it a different way to me in a similar manner, and it would also make sense. So it sounds like yes, I agree that that had that high number 18,000 newtons of force been applied on this fall, there would probably be more.
DD Head 420 just sent a super sticker
more
with
injuries.
0.99.
DD Head 420, thank you so much for the super sticker. Trees on the ski slope, apparently. I appreciate the super sticker. Thank you. I think that if the BAME's calculation was used and 18,000 newtons of force were applied on that crash, you would see more injuries than just broken ribs. There would be internal damage as well. And I think this expert and his expertise and his experience beating the daylights out of cadavers, which he described in many different ways, probably can testify to that.
I was kicked back, taking it easy.
This guy is great. I like him. So did that answer the question? I am buying this more than I bought the other one, and maybe it's because the other one didn't explain it in a way that I could understand. But this Pictionary really helped. Pictionary and charades. Rolling steady. I don't have the video of that. It actually happened off screen, so we were looking at the judge when that laughing clip, the cackle clip, happened. Let's see. This guy's worth a gazillion. Stick drawings are visually effective. There's Mr. Terry right there coming back in. Wearing a blue tie. It looks almost like a Christmas tie. Is that like a snowman on it? Skiing snowman or something? Not sure which.
Bring the jury.
It's not just a floating head, but the floating head from Florida where there's no snow. Well, he was from Florida because his daughter was getting married down there. I'm not sure if he actually lives down in Florida. That's why he testified over Zoom. I wonder if the witness maintains copyright for his drawing in court, or if I can put it on a T-shirt. Matthew, just go ahead and use it. I think you're good. How long before they show the cartoons? The cartoons are going to be the videos we saw yesterday, the animations that were almost video quality, very high quality animations. It's not going to be animated stick figures, unfortunately. It would be good if it was, but that won't happen.
You're talking about stuff that is not relevant.
Cross will be like, does it bother you your stick figures aren't in color or to scale, or that they have different length of legs? I smell a lawsuit. Deer Park should sell the shirts in their gift shop that say "Don't be a Terry." Deer Park, the witness prior to this, who was that? The ski patrol guy. They don't have a dog in this fight anymore. As soon as the case against them got thrown out, they're just like, we don't have an opinion. We're not going to come down one side or the other. Everything's normal. We're not going to be on one side. They are definitely not taking a side, and I think that's in their best interest. And it did definitely bother the plaintiff, Mr. Sykes, his attorney. Yes, copy it very quickly and make the T-shirt before he does, and then tell him that you had it first.
Everything working now?
Yeah, sorry, that we had plugged it in before, somehow it got unplugged, so it's out of batteries.
Okay.
Dr. Schur is using the restroom.
Okay. All right.
Dr. Schur is using the restroom. The computer is charging.
Have the jury come in.
And we're going to bring the jury anyway. Nicole Goodman Law Firm comes in and says, in civil trials, jurors sometimes will tell you that when there's battling experts, it all comes down to who they like better, especially if they both have credibility issues. So far, I don't see a credibility issue, but of course that will probably pop up on cross, not on direct. If it comes up on direct, you've got problems with your expert. So we'll see what happens on the cross. Let's see. Red pen, that's a great observation.
Dr. Scher, you can take the stand.
As far as I talked to you guys about the judge's robe and the ski instructor's pullover, I was looking for one like that. I found there's a company that makes judges' robes, and they actually run like $450 each, and they are custom tailored to the judge.
Yes. Yeah, she's back, taking it easy.
You can choose like 6 different types of materials, the sleeve, whether it's tapered or cuffed or straight, zipper or buttons or clasps. You've got all these options. So yeah, $450 for a high quality judge's robe, and I imagine he probably has a few in case he spills something on one. He can go back and change it. But it's like a suit. It's like buying a suit. I mean, it's not just a black sheet with a hole cut in it. You can't just wrap up in some dark curtains and call it good. The defense was who mentioned Dr. Bain being in Florida with a green screen, so that jab might be even more unfair. Well, Dr. Bain was the plaintiff's witness, so defense was making fun of him, and I think the plaintiff's attorneys are going to make fun of this guy for the stick figures. They're going to go there. It's like pilot uniforms, very personalized. Yes, monograms, all sorts of stuff you can get on the judge's robes. Now you can get a very cheap one, for $15-20. It's basically a graduation robe or graduation gown. But look at the pleating locations, how the sleeves work. I mean, this judge is currently, he is comfortable.
Alex stole it.
There's no pinching across the shoulders as he reaches. It's very pricey. Lots of options. I think the website that sells them. Let me see if I can find that here. Who was it? It's Oak Hall Cap and Gown. Now they do graduation. Like doctorate level graduation things as well. So they cater to professors and judges, I think. Oak Hall, if you really want a nice one, I mean, if you want to look the part, you'll have to pay dearly. But let's see. Adam says, I think I confused RA, but hopefully I'm making sense to someone. I was confused, I think. Let me see what you said.
Thank you, Mr. Egan. You may proceed.
Yes, thank you, Your Honor. May I approach to show the witness the animation?
You may.
So this animation is number 5, correct?
It is.
It's called Close Up, and I'm going to play it for you.
Yeah, we get to see all the animations. That's good, and we shouldn't have cutout parts for where they didn't, where the witness didn't see that part of the event happening. So we'll get to see the crash, and I will move my head. I'll move my head, and if I have to, I'll take a different feed so that the logo doesn't cover anything up.
Sure.
Which number is it?
5.
Number 5. It's called Close Up.
Any color you want, as long as it's black. That's
22
correct.
seconds.
No, don't buy me one. I'll get my own judge's robe. Don't worry about that.
So again, Mr. Scher, Dr. Scher, you're maybe explain to the jury your involvement in creating this animation.
Sure, I worked with
drew them all myself.
Brian Brill at Mountain Graphics on the impact and fall portion of this animation. It's not meant to represent exactly what happened, but generally the idea of one of the family of ways this could happen in Miss Paltrow's version. We don't know some of the exact details of how they contacted, how long they interacted, but it gives an illustration of what I'm thinking, my understanding of her version where she's contacted from behind and then fall to the right.
And does the animation make certain assumptions about various facts and testimony in the record in this case?
Yes, it does.
Okay, and you can explain those to the jury as we go through it?
Sure, yeah.
And the animation will help you explain what you said earlier about biomechanics, applying biomechanics to this case?
Right, exactly.
Okay, so permission to publish this to the jury, Your Honor?
We assert our ongoing objection to the animations or cartoons. They lack foundation, distort the reality, and are incomplete.
So animation number 5 is received for demonstrative purposes only to help this witness explain his testimony.
Thank you, Your Honor.
Okay, here we go.
So, Dr. Scher, I'm going to let you take the reins here and use it as you need to explain, okay?
Thank you.
Is that all right?
It's a Dell. It's a Dell computer.
I also object to the extent that this witness hasn't testified to any of the placement of any of the other skiers or bodies in this animation.
Mr. Egan, is that relevant to this witness's testimony of the other skiers?
No, he's going to talk about the collision itself.
So you should ignore any of the other skiers that are shown in the animation.
Okay, so you can reverse it, Dr. Scher, to just before the collision, so we can focus on that and explain what you mean to show by this animation.
Maybe I can't. How do you?
You can press play again.
We're jumping right to the heart of the matter here.
We go.
Okay, there you go.
Yeah.
Okay, great. So, take us through,
This is better than the GoPro
if you would,
footage.
Dr. Scher, what this animation shows from your point of view as a
Sanderson's in
biomechanics
blue on
expert.
the right, or in the middle.
The first thing that you should be aware of is that this is Miss Paltrow's version of the events. So,
Dr. Scher, sorry to interrupt you.
Oh.
Just maybe pull your mic.
Sorry
Yeah,
about
there
that. The first thing to be aware of is this is Miss Paltrow's version of the events. So that's what we're showing here. And as we move forward, I'll talk about the physics, kind of like what I drew earlier with the center of mass and the rotation. And that's the idea. That's what went into this. But again, this is not exactly what happened. This is just one of the possible ways it could have happened.
The person in green is just a woman who did not stop, and nobody knows who they are.
We have Miss Paltrow in black, Mr. Sanderson in the blue, as they move forward in time.
Let's put it up full screen, please.
It's her testimony that his skis slid between hers. There we go. She felt a contact directly in the back, along her back. It sounded like her buttocks as well. The person was grunting, pressing against her, but they were on their skis for a period of time. If in this situation he's also moving to skier's right, which is in the left in this image, that will create, remember I had the force that was offset from the center of mass. That's going to create a rightward motion for her, but also create some initial rotation. Now, in this portion, there's a number of possibilities. She could be adding weight to her right ski because of the contact from Mr. Sanderson. When you ski, if you're in, let's just take a snowplow or what my kids call pizza position. If you weight the right ski, you turn left. So if she weights the right ski here more because of the contact, she's going to turn counterclockwise. The contact from Mr. Sanderson, if it's more to the right, will turn her counterclockwise. So as they're moving to the right here, there would be some counterclockwise rotation, and here her ski can catch, or she could pitch to the side, or they could both pitch to the side. They could both lose balance. We're not sure what happens, but as they're rotating, they're continuing to fall, and Miss Paltrow's version has them spooning essentially as they're coming down together, which would make sense if their legs got caught up. If he was contacting her below her center of mass where his right leg was contacting her right leg, her thigh in that area. Also consistent with Ms. Paltrow saying that her right knee was splayed open at the end and she felt right knee discomfort. That all could happen there. So as she's rotating and he's rotating counterclockwise, they fall to the side. Now, at this point here in the animation, I guess maybe the next frame, if I can do it. Mr. Sanderson lands on his right side, maybe the right back. It's hard to say. If he lands on his right side, kind of like Dr. Boehm said, he needs to land on the elbow, that can happen. That can create lateral rib fractures. But that's not the only way. His arm could be out. He could land on the side and create lateral rib fractures. He could land on his side and a little bit towards the back, and Miss Paltrow could land on him. She could be fully on him, maybe with her buttocks or her back or some portion of her mass compresses his chest front to back, and that can create his rib fractures. There's a lot of different ways this could happen. I can't tell which one of those is right, but all of those are consistent with her version of the events. As they hit the snow, they would continue to move forward until friction slows them down. And it's also important to note, we haven't talked about the head injury, but hitting the back of the head or the side of the head, he could have his head turned. All of those are possibilities for him to contact his head on the snow. So that's not inconsistent as well.
Would it be helpful to show it in real time? You've been doing it kind of slow motion, which has also been very helpful. Maybe start from the beginning and just
check
play
to
it.
real time, but
Objection lacks foundation for trajectory, speed, and direction.
That's the objection.
Overruled. It's demonstrative of this witness's testimony only.
All right, thank you.
Okay,
go ahead, Dr. Scher.
This is from the beginning.
And if there's anything you want to comment on as it happens, feel free.
There you go. Sanderson's swinging wide. Paltrow's going nice and slow back and forth. Boom. There are the skis. That's where she says, "What the fuck are you doing?"
The version that Miss Paltrow testified to that matches the laws of physics and biomechanics as I understand them.
And would it be helpful to show, there's one other animation that has a little zoom in from the other angle. Would that also be helpful?
I think, it can't hurt.
Let's show that then. Permission to approach, Your Honor, for that. Okay.
The hardest part for me to understand
this will be
is the skis between her skis.
4. It's called zoomed inside.
Right at the point of her turning.
What was the last one, James?
Number 5. Oh, sorry. Yeah, thanks. Okay.
Wait just a sec.
Yeah, if it happens slow, you're right, Nicole.
Okay, Dr. Scher. So I'm playing you number 4, the zoomed in from the side version. Were you a part of creating this version as well?
Yes, this is the same animation, but from a different camera view.
Got it. And will this animation also help you explain the same things you've been going over with the jury?
It's the same thing, sure. Yeah, I think it also visualizes, it illustrates my opinion.
Okay.
If she got in his way, that would make him to be at fault.
Subject to the same objections by the plaintiffs, the animation 4 zoomed inside is received for demonstrative purposes only. 4.
Okay, thank you, Your Honor. So,
okay, here we go.
Dr. Scher, maybe since we've already gone through this slow motion, let's just play this one from the start, and then you can add anything that you can provide to the jury from this angle.
Sure. Here, let's play first, and then there we go. I'll wait until the contact point.
I'm not sure why Gwyneth is skiing in that position while everyone else seems to be completely upright.
It's coming up. Here we go. There's contact, fall to the right. This one doesn't show the rotation quite as much, and we don't know the amount of counterclockwise rotation as well. There could be a little, there could be more or less.
Right.
We're not sure.
But if you go backwards a little bit into the moment of the collision, this one maybe shows. Does this one show the skis coming between the skis?
Yes, it does. And I think it's better visualized in this one.
Yeah, and again, what's the significance of that in terms of how the mechanism of the fall occurs?
Well, that's Ms. Paltrow's testimony, and it works for the physics of them falling and rotating slightly counterclockwise. Frankly, if it wasn't both skis, if it was one ski between hers, the kinematics would be the same. For example, if his right ski were on the outside of her right ski, it wouldn't change the general kinematics. This is generally, and I keep saying generally because we don't know the exact details of it, this would work.
So if we flipped the positions of the parties and Mr. Sanderson was in front, Ms. Paltrow came from behind, using this as a good visual for the jury, will you explain your opinions about what you would expect to happen on Mr. Ramon's account, I should say?
Well, Mr. Ramon's account is very different because in Mr. Ramon's account, Mr. Sanderson goes spread eagle and his skis go out into that V and the inside edges catch. And that changes the kinematics, the motion. It's a very different version of what happens with the contact.
And in terms, I guess we've covered that. So maybe we'll wrap up here. You've covered a lot of things, a lot of new things perhaps for members of the jury and those of us in the room. Will you summarize for us what are the main points that you want to get across for the jury here?
Sure. The first is that Dr. Boehm cannot say with any accuracy that Ms. Paltrow landed on Mr. Sanderson. His calculations are wrong, and when you look at the equations done properly, Mr. Sanderson can land on the snow and sustain his injuries without Ms. Paltrow falling on him.
And if I may, Dr. Scher, was it your understanding that Dr. Boehm's opinion was that his account was the only possible way the injuries could occur?
Yes, Mr. Ramon's version was the only possible way. He said Ms. Paltrow's was impossible, which I believe is false. I think Ms. Paltrow's version is possible.
Right. And would you say that Ms. Paltrow's is the more likely of the two accounts?
Well, considering it's the only one that matches with the physics of what would happen in contact, yes, I think so.
That was
okay,
important.
And I interrupted you. You were going through your main points. What was the next one?
I think we've covered it. The second thing is that Dr. Boehm cannot say that Ms. Paltrow's version is impossible. That's absolutely wrong.
It sounds like you're saying, in contrast to Dr. Boehm, that there are various ways this accident could have happened, the injuries could have occurred for Mr. Sanderson. Is that right?
That's correct.
And you've evaluated the various testimony, correct?
I have.
And you've done a careful analysis from a biomechanical engineer's perspective on what different scenarios might be likely or how they would happen, correct?
Correct.
And is it your opinion that Ms. Paltrow's version is the more likely of the two versions that you looked at, Mr. Ramon's and Ms. Paltrow?
Yes. Once again, it's the only version out of the two that matches with the laws of physics, the biomechanics of it.
Okay. Anything else you'd like to tell the jury that maybe I interrupted you on and you missed out on?
No, I think we're good.
Okay, thank you. That's all for now, Your Honor.
Can you keep the screen there?
Sure.
You can turn it off. Well, actually, leave it on for right now.
On or off?
On.
Okay.
Gathering up all the posted notes and everything.
Or do you prefer Dr. Scher?
Sure, that works.
Sure, Dr. Scher? Okay. This version right here.
Got to crank the volume here, sorry.
Can you back it up about to here on the scroll?
To here?
Yeah, and then go forward it out halfway between the last one. Okay, a little farther. Just before when Mr. Sanderson, who's also
maybe it's easier if you do it.
Well, could you just go a little bit farther forward? Just go slow. I just want to get Mr. Sanderson, who's sometimes called Dr. Sanderson.
Mr. Bueller, would you mind putting on the remote that allows you to be picked up?
Mr. Sanderson, who's sometimes called Dr. Sanderson. See how he just slid that in there?
Is this working? Oh, wait, now it is. Okay, go a little farther forward, please. Okay, and then when we get, okay. Now, this is Terry Sanderson.
That's Mr. Sanderson, that's right.
Okay. So his right eye is, okay, go a little farther.
He's using the microphone as a pointer instead of as a microphone.
Fractions, a little bit farther. Okay. So you have his head turned. That's based on your testimony that he is looking down the hill, I guess. Is that what you're saying?
I believe his testimony is that he's looking at a woman who's a little downhill to the left. He notices her, looks at her. I don't remember what the exact words are.
Okay, go a little farther.
Still using the microphone as a pointer.
So his head, his left eye would be looking directly at Miss Paltrow. He would see her, right?
I believe so.
And it's inconsistent with his testimony. He didn't see her at all.
That's correct.
Yes, he's lying. We agree on this point.
I would think so.
Okay, go a little farther, just another fraction. Okay. Now, in this picture, you don't have Craig Ramon in there. How far above would this point be? Where I just pointed. How many yards would that be above this image right here?
I don't know without doing a measurement, but I'm concentrating on the collision between Mr. Sanderson and Miss Paltrow.
Well, Craig Ramon testifies he was about 30 to 40 feet above. And so these objects are about bent over, maybe 5 feet high. So if we just flop over, 6 bodies, we'd get to 30 feet. That would be about right here.
I'm not sure.
Well, you're an engineer, highly trained PhD. You can't even guesstimate that that would be about 30 feet?
I can't tell.
Would up here be 30 feet?
They should object.
Don't you think it would be a lot more than 30 feet?
Probably, but I don't know.
Well, you helped create this animation. You don't know the distances in your own animation?
No, I've concentrated on the collision portion. That's the biomechanics portion.
Okay, who did the estimates or guesstimates of the distances of the bodies of the other people?
So that's going to be Mr. Boggart, who's going to be on soon, I assume.
Okay, so this animation doesn't have Craig Ramon in the scene at all?
Not at this point.
Okay. Is it because the defense doesn't want him in the scene, so to discredit his witness account?
Oh, I don't think that's the case at all. You'll have to ask Mr. Boggart.
Okay, we will. Okay, let's see. Just go another little section.
If I were this witness, I'd go really far forward and back and far forward and just frustrate the daylights out of this guy. Skip the parts.
You just tell me when. I'll keep going until you say
just
stop.
Go slow. I just want to go slow motion. Okay. Now stop right there. Now, do you know the time, how much time from the initial, let's say, impact of their bodies to this point would be? You did this calculation. This is your You're bailiwick. You're what you're talking about.
Do you mean in the animation, or do you mean in real life?
Right now. Yeah. Yeah, from the impact to this point, approximately. Is it like a fourth of a second, a half a second, tenth of a second? Do you?
Ms. Paltrow says that they're in contact for a little while, a few seconds before they fall over. So I don't know what it is in particular in this animation, if that's what you're asking.
So you helped design this part of the animation, so you don't know how far it is. You just guessed it?
Again, we don't know exact timing and distance. This represents an illustration of the version. So, yeah, it is what it is.
It's an illustration of the version, but there could be wide variability in that version, right?
There is variability, but we have constraints on it.
The constraints are, it could have happened the opposite way, right?
The opposite way.
Ms. Paltrow hit Terry Sanderson.
No, I don't think so. Not with the testimony that's given. We have two versions. We have Mr. Ramon's version, and we have Ms. Paltrow's version. This is Ms. Paltrow's version. Mr. Ramon's version is very different.
Okay. Let's talk about that for a second.
You hold it, you put it by your mouth when you talk. That's how it works.
You're being paid, excuse me, you're being paid,
just go to the money. Yep.
Is it $4.25 an hour for this?
No.
Is it more than $4.25 an hour?
It is.
$4.50 an hour?
Yep.
500?
It's 500 an hour.
500 an hour. And you billed something over $10,000 so far for your work?
That sounds about right.
More than 15,000?
No, I don't think so.
So between 10 and 15,000. Okay. You can turn that off for right now.
I think that's probably better.
No, please leave it there.
Oh.
I may come back to it.
What's the best way to, do I just disconnect it? Is that? Yeah, maybe just disconnect it. Like that? Okay.
The battery's going to go dead again. Watch this. This is eating up the plaintiff's time.
No, you're here to teach the jury, right? The defendant's version, correct?
Teach the jury the physics that would be helpful in understanding how to assess the accident.
So that's a no. You're not teaching the defendant's version.
I'm not teaching any version. I'm teaching the physics and mechanical engineering, biomechanical engineering that would help the jury.
I know it's hard for expert witnesses to say yes or no, but are you teaching the defendant's version?
I guess I don't understand the question.
Okay. Seemed like a simple question. Next, I'd like to
no objections.
Talk about, did you review Dr. Gibby's testimony at trial?
No, but I did see some of his trial testimony.
All of it or some of it?
Some of it.
Was it more than 10 minutes?
Probably, yeah.
More than 20 minutes?
Yeah.
More than an hour?
I don't think more than an hour.
Okay. You didn't disclose anything about hearing Dr. Gibby's testimony?
I'm not sure what you mean, but I did see it.
Okay. You've never disclosed to the plaintiff your reports or your testimony ahead of this trial, correct?
Your Honor, may we approach?
Yes.
Okay. Mark it down. This is sidebar number 2. We went quite a while without a sidebar compared to yesterday. This one is called by the defense or defendant. Not very many objections today. The defendant has not made any objections. I think the witness is doing a good job. We'll see where they're going here with this. I like these types of arguments. Like you didn't tell us what you were going to say. That you're supposed to tell them what you're going to say. They sort of get to preview your testimony so they can prepare for it. 10,000 to 15,000. This is pretty average for an expert witness. I think you would be surprised at the numbers that the lawyers are getting in their fees. If you want to look at math and who's getting paid a lot in the case, they're getting paid a lot. Although probably, I'm not sure if it's the same billable rate of $500 per hour each. But Terry's got 5 of them sitting there, so he's not worried about the money right now, apparently. Expert witnesses aren't typically sequestered or otherwise under the rule if observation of the other testimony will assist them in providing their expert opinion. Yes, they are allowed to watch the other testimony normally. And they're also, as an expert witness, they're allowed to speculate. They can ask questions, or they can answer questions. Say, I think this is how it probably happened, using their expertise. Georgia Culture says, I voted sustained. I don't remember what the objection was. I think the defense or defendant had, Clark Kent had objected to the line of question about how much, no, it was after how much testimony it was. It was the providing information to the plaintiff. They may be on contingency, Kaylee. Like they get paid if they win.
Are you an expert on broken ribs?
Oh, it was sustained.
I am comfortable talking about the biomechanics related to rib fractures.
Have you done any papers or studies or research on ribs and rib fractures?
Me personally, no, but I've read the biomechanical and engineering literature relevant to them.
Okay. You haven't mentioned that biomechanical literature in specifics, correct?
I'm not sure about in specifics, but I think we mentioned it on direct.
Okay. So you said that Dr. Sanderson, or I'm just going to call him Terry. Terry was 70 years old at the time of this crash?
It was 69, but effectively 70 for biomechanics purposes.
Effectively because 70 years older?
No, because there's actually good information in the biomechanical engineering literature about the amount of chest compression required to create rib fractures for 70-year-olds.
And not 69-year-olds.
Well, it's actually the full distribution, but the paper that I'm thinking of from Agnew specifically talks about 70-year-olds.
You didn't mention that paper today.
No, but would you like it?
Not right now, thanks.
He's got it with
him.
him.
I've not seen it. Let's see. I'm going to go right to another point. You have this theory of rotation, correct? That the version you're calling Ms. Paltrow's version is a kind of a rotation version?
There is some rotation. It may be a little. It might be more than a little. We don't know.
Okay, so we don't know how much rotation there is, correct?
Sure.
Okay. I'd like to... Let me see if this thing works. It didn't work last time. I guess it's working now.
They may be stalling for time intentionally to cause the other side to to be in a bind, not be able to get all the witnesses in they
Take a
want.
picture of this?
I think you've already done it.
Okay.
Or someone on your team has.
Okay, good.
Oh, somebody already got a
May I
picture
borrow
of
a
the.
pen?
He's going to color all over the stick figures? Oh, come on.
Your Honor, we would object to him writing on the witness's board.
It's not an exhibit. It's certainly fair game.
Okay.
So,
Well,
Doctor,
can we mark it as an exhibit, Your Honor?
Why don't you take a picture of it and you can use that, and then he can
Go ahead,
add,
take a
he can
picture.
add to it.
Okay.
How comes the cell
It
phone?
is our board.
right.
It's
in-
our
in
board.
Academic
We
fields,
don't have any questions right now, so.
in academic
want him
fields,
coloring
it's
on
common
the board.
that people write on each other's drawings, correct?
I don't know that I've seen that, but I don't have a problem with you drawing.
Okay. So, you testified that Craig Ramon says Terry was hit directly in the back, and they went down, and Craig Ramon was somewhere above, 30 to 40 feet, and it happened in a fraction of a second, correct?
Yes, the fall, I would agree with that.
Okay, less than a second.
Sure.
Okay. So there was a scream. So and the scream occurred, and there was within a fraction of a second. And I don't believe Craig Ramon never testified where Miss Paltrow's skis were.
Correct.
So her skis could have been going underneath Terry, like this. So the pink ones would be Miss Paltrow's skis. Is that a version that is possible?
Doesn't show up.
It is not.
It's you're saying it's not possible.
That is not possible with the version that Mr. Ramon states.
His version didn't talk about her skis. Now here, I'll draw what her body. The pink would be her body, still square in the back. Isn't that possible?
So, no, with Mr. Ramon's version, if I may, that is not possible. So, in this situation here, when Mr. Sanderson's skis go into a V, and I guess you're saying her skis are under his skis, which I'm not sure how that happens because the tips curve up, but we'll go with it. Somehow, she winds up in this situation getting caught with her left ski around Mr. Sanderson, and she would not continue past 5 to 10 feet, and I would expect a twisting release of her left ski.
Well, that's her version. I'm talking about Mr. Ramon's version.
No. I'm talking about what you just drew for Mr. Ramon's version.
Mr. Ramon's version. Well, isn't it possible her skis could be pointing straight like this? And let me get it right here. So, yeah, so she could be going straight, and she could be turning left and up and hit square in the back, but her skis are pointed this way. Isn't that another version?
So for her skis to miss...
No question.
Oh, no, it's not. Do you want me to explain?
In a second. I'm asking the questions here. So, so are you saying that her body could not be turned while her skis are going in one direction, or she's turning up to the left? Is that possible?
Not for Mr. Ramon's version. Is it possible in general? Sure. But in her version, I'm sorry, in his version, no.
This happened in a fraction of a second. I don't think Mr. Ramon testified that he has a videographic or photographic memory. Do you?
Well, he's pretty particular in his testimony about how she was on Mr. Sanderson's back.
Right, and he could. You see the circle I have? Let's see. Well, actually, maybe I could do it. I've got it wrong. Let's do it the other way. Her body could be like this, and her skis could be like this too. And people turn all the time while they're skiing, and their skis are going one direction, but their body is pointing a different. Right here. Can you see me? You see that?
I see you turning, sure.
That's possible, right?
What you're doing in general is possible. Are you asking, does that match with Mr. Ramon's testimony? No, and I'm happy to explain why.
I think Mr. Ramon's testimony is, it happens in a fraction of a second. Mr. Ramon, a professional wannabe freestyle skier, likes to talk about ski angles, but the main part is the body. He saw the body, and then the bodies go down together, and she lands on top of him.
Did you say professional wannabe?
Versions, which are not based on anything except your recreation of the biomechanics, are superior to an eyewitness. Isn't that what you're saying?
No, we have two versions of the accident. We have Mr. Ramon's version, and we have Ms. Paltrow's version. I've assessed both using physics and biomechanics, and I'm sorry to say Mr. Ramon's version does not meet with the laws of physics. It's not consistent, internally consistent, and Ms. Paltrow's is.
Well, I don't think Mr. Ramon's version was designed to be consistent with the version of events. It happened in less than a second.
It wasn't designed to be.
We don't know the
consistent with
direction
physics.
of the skis. In his version, he never testified to the direction of Ms. Paltrow's skis in any of his testimony. Isn't that true?
He did not testify to the direction of her skis. That's true.
Thank you. So, if Ms. Paltrow was skiing down, turning up to the left, she hits Terry Sanderson square in the back, and they can fall down to the right, especially if her momentum is going, well, you know, I'm not a biomechanical engineer. I'll try to do it right here.
Please pan over. Please.
It could be her shoulder that hits him square in the back, couldn't it? He didn't say what part of Miss Paltrow's body hit Mr. Sanderson.
Terry did.
He did not say. He said, well, here, I can tell you exactly what he said. He said...
Take your time.
Yeah, they are trying to stall here.
He said, squarely in the back. She couldn't have hit him in the back any better right in the middle than if she tried. And she couldn't have been back on his back any more than if he would have strapped her on the back, like a backpack.
Okay, but that doesn't mean her body was straight.
Might not be exactly straight.
Yeah, it could be off center because she was skiing down. She's like this, and she hits him right in the back. Or maybe it was a little off center because Mr. Ramon only had the view for a few seconds. And then her arms wrap around, her arms could have wrapped around Terry Sanderson, right?
I don't think there's any testimony about that. Is it possible? Maybe, but...
Well, where would they have gone? Down to the side? She went in like this?
In front of her?
I mean, the most likely, don't skiers ski like this usually?
Often.
Often? What are the other positions?
They can have her arms in more.
Okay.
So have them out more.
So she could be like
have
this,
her arms down
and
to her
turn like
side,
this.
and the poles heading back.
Okay.
There's all sorts of options.
So in that fraction of a second, Mr. Ramon saw the collision. The screen was up here. He turns his head, and she could hit him square in the back. She could have her, at that point, her body could have turned and possibly hit her, but the point is the skis could have been going at a different angle, one or the other, and still cause this crash. And your versions assume those are not possible because you assume that there's only one way, that their skis were going parallel to each other. This is your only assumption, right?
Wrong.
You assume, you made assumptions that these are possible?
I looked at other angles. That's right.
And the testimony, though, you said there's no testimony about the angle of her skis from Mr. Ramon, correct?
That's true.
You've made a lot of assumptions, correct, to make these animations, right?
Yes and no.
I thought that would be more than one assumption.
There are
That's
some
a yes or no?
assumptions. Sure, more than one assumption.
Okay. Less than 100?
Sure.
Less than 10?
I don't know.
You don't know how many assumptions you've made, correct?
That's right. Sure.
Okay. Now, I know counsel, Mr. Owens likes to do this a lot, like it's a touchdown, but on redirect, Mr. Ramon, did you see all of his testimony for this trial?
I don't know if I saw all of it, but certainly I saw a lot of it.
Okay. You saw the testimony last week, correct?
Is there any more than that?
There was a little bit yesterday.
Okay, I didn't see anything
Had nothing
yesterday.
to
I
do
was
with this.
traveling.
Had to do with that Mr. Ramon reported what he saw the same day and the same week 7 years ago. And you're recreating this, what, about 5 months ago, correct?
I don't remember when it was.
Less than a year ago.
I don't recall.
You don't recall when you consulted with Mr. Brill and made the animation?
This has been ongoing for a while. This case has been dragging on, so I don't know when it was.
So you've been working on this for, let's say, more than 8 months?
Sure.
You don't know?
Certainly we've been in contact with counsel for longer than 8 months.
And for the record, Your Honor, I'd like to move to strike all of his testimony because this wasn't disclosed improperly. I anticipate the ruling, but I just want to, for the record, make the ruling.
It's overruled. It was disclosed properly, counsel.
Okay.
It wasn't disclosed improperly is what he said. He meant it properly.
What I'd like to do is understand that you've made a lot of assumptions, and the jury would like to know how reliable your opinions are. So how can that be reliable when you totally discount some major events like what the direction of Miss Paltrow's body was compared to her skis? And there is testimony about Miss Paltrow's body movement. Do you know that?
I guess I don't understand.
Prior to the crash? Just prior to the crash?
What version are you talking about? I don't know what you're talking about. Sorry.
Do you know about the version of Carrie Oakes?
I don't think she saw the accident.
Have you read her deposition?
I have.
Okay. You realize she testified that one of the kids said, "Mommy, watch us ski," and the kids were up there on the left. Miss Paltrow was down on the right, which would tend to show that Miss Paltrow was looking up to her left at the point of collision.
I don't recall that.
Okay. So you're excluding Carrie Oakes' testimony, correct?
That's wrong.
You're including her testimony?
I considered it, sure.
And are there any assumptions you've made based on her testimony?
Look at orange shirt guy. Look at his
Not in
facial
particular that I can think of, but there may be.
So could you speak up?
Not in particular that I can think of.
Okay. Not particularly that you can think of about Carrie Oakes' testimony, okay? Are you an expert on head injuries?
I'm comfortable talking about head injuries from the biomechanics standpoint.
Have you ever studied or held yourself out as an expert on concussion?
If it's diagnosing or treating concussion, no. If it's the biomechanics related to the formation of concussion, yes, I've done helmet research and head injury research, in particular for snow sports.
Did you apply any of your knowledge about concussion to this case?
I certainly looked at it, but Dr. Boehm was very particular in his testimony that it was only the rib fractures that allowed him to say that Ms. Paltrow contacted Mr. Sanderson from behind. So that's what I concentrated on for the jury.
And you ignored his discussion about the head injury?
Oh, no, I certainly considered it.
And it's not relevant in this case?
Well, in disproving Dr. Boehm, it's not relevant, but I'm happy to talk about it.
Okay. Well, it's not clear you disproved Dr. Boehm when you don't even know the direction of Ms. Paltrow's skis at the beginning of this. It's also, I think, a big assumption to say what the body position of Ms. Paltrow was when she hit Terry Sanderson in the back.
Objection.
There's an objection.
Was there a question in there, counsel?
Just if that was accurate. I'll withdraw it.
That's the first objection from the defendant. Table. I think Orange Shirt is mimicking the facial expressions of the jury members, because I think there are some that are pretty involved in the testimony. That's just my gut feel.
So you've never studied rib injuries. Have you ever testified about rib injuries before?
Could you clarify what the question is?
Have you ever studied rib injuries and testified about them in the past?
That sounds like two questions.
Have you ever testified about rib injuries in the past?
Those two questions.
I don't recall, but it's likely.
Most likely you have?
I think so.
How many? Have you testified more than 100 times?
In trial, probably 35 times, something in that ballpark.
In total, under oath, have you testified more than 100 times?
Including depositions, yes.
More than, less than 200 times?
I would agree with that.
Okay.
The judge did ask him to clarify the question without prompting from the defendant table.
Let me just check.
Like, sit down.
That's all I have for now. Thank you, Dr. Scher.
Thank you.
Thank you, Mr. Bueller. Mr. Egan?
He's going to be quick.
Thank you, Your Honor. Dr. Scher, we'll just be real quick here. Did anything Mr. Bueller asked you change your opinion that Ms. Paltrow's account is consistent with the laws of physics to your understanding and Mr. Ramon's is not?
That remains the same.
Thanks.
Mr. Bueller?
Just, I think you said this before, that you're an expert in the laws of physics, but you're not an expert in medical medicine or orthopedics or neurology, correct?
I am a biomechanical engineer. I am not a medical doctor. I do not diagnose and treat, but I do look at what forces and what motions create damage to the body.
You may step down.
This witness should get a bonus that's double whatever his regular rate
May
is.
call your next witness.
I have never seen an expert witness that's done that well under cross and enjoyed the experience as much as he did.
Bogger, Your Honor.
Thank you.
Your Honor, before Mr. Bogger comes up to testify, we may want to take a 5 or 10 minute break. I want to address something with the court outside the presence of the jury.
We'll have to take one shortly anyway, so let's go ahead and do it now.
Okay, so we're going to call this another sidebar at the request of the plaintiff. It's number 3. Bogger's coming in. Not Booger, Bogger. Who typed that? Maybe I just read it wrong. I think the jury probably connected with that guy. How do you not laugh and just enjoy the experience as somebody draws stick figures in 3rd grade style to explain something they've gone to school for,
Your Honor, pursuant to our motion in limine, Mr. Bogger's testimony is going to be significantly limited in this case. The problem that I am foreseeing is that, I could be wrong, but it appears to me that counsel is going to try and use Mr. Bogger to then describe some further animations and place individuals on that animation, and I have significant concerns with that for a number of reasons. Number one, Mr. Bogger's not qualified to do that. He didn't take any kind of measurements, calculations, determinations of speed, force, physics, etc. in this case. But in addition, in his report, he does not make any mention of where people were, where they were placed. Any kind of discussion of him talking about the animation, and if he was responsible for putting the people somehow on that animation, he does not describe that in his report. He doesn't talk that in his report regarding participating in an animation. He provides no diagrams in his report, no discussions of where people were or weren't. So I don't think that it would be appropriate for him to even deal with the animation, or that his testimony that he's the one that was responsible for putting, say, Apple here and Moses here and that type of thing. That would go significantly beyond anything he did in his report. So that's my concern, and I wanted to address that now rather than a sidebar.
Okay, thank you.
John, may I quick take a photo of this?
Sure. Mr. Egan?
Yes, Your Honor. So I think our response would be that Mr. Bogger has poured over the records in this case, and he has, in producing these animations, made certain assumptions about what testimony might be consistent with the illustration that the animations provide. He can be very clear with the jury that he's assuming certain facts. He's not finding these facts. He's assuming that they're true. They come from the record. He can explain that they're rough illustrations. He's not made measurements and decided that, yes, this is exactly 30 feet. He can be subject to cross-examination on any point that might be inconsistent with testimony. He can explain that he chose to assume these facts and not other facts, and that if you assumed other facts, you might get different illustration. And then he will explain that the assumption of various facts that are shown in the animations are consistent with his understanding of ski collisions and skiing generally, which he has decades of experience, not just with skiing himself, but with investigating accidents, collisions, hundreds and hundreds of them for various purposes, mostly not litigation, mostly to figure out risk management concerns, deciding whether certain skiers have to be banned from a certain resort or a ski area. He has ample experience to be able to discuss how to consider various factors in evaluating a ski collision like this that has complex testimony that's not all consistent. And the jury, in our view, needs to hear from a ski expert that knows how to do that and can explain to them the principles that he uses. He will not tell the jury this is likely what happened, or that I have found that this must be the case. He'll say, I've assumed these facts. He can be very clear about what he's assumed, and then use that animation to explain to the jury how to think through the case, given his ample experience with evaluating ski collisions.
So, Mr. Egan, I guess I'm still not hearing an expert opinion from Mr. Bogger, is it?
Yep.
That
he's not going to be able to speculate.
Help the jury. I mean, everything that I'm hearing has him weighing evidence, has him making decisions about what may have happened on that day, and that's invading the providence of the jury. It's not really going to help them.
Your Honor, I see it as like, say, a medical malpractice case, which I'm more familiar with. If a certain set of facts might be in the record about what happened in a surgery, for example, then a surgeon, expert surgeon who has lots of experience reviewing records, but also doing the surgery himself, knowing what the training is, looks at the records, looks at the various claims, and you, as you said in your order ruling, I believe, yesterday can say, if we assume these facts, given my expertise, I can say this makes sense,
He's
or
not
this
an
is
expert,
consistent
though.
with my understanding of
The expert
surgery.
designation is what's in question here.
And so my proposal is that we use Mr. Bager in that sort of way, where he can help the jury understand, given what he knows about skiing and given what he's seen in the record, that there are certain principles you can use if you assume certain facts to evaluate a certain collision, such that you're applying some rational principles rather than just generally going with a certain gestalt feeling about what someone said. You're actually trying to rationally go through how to evaluate a ski collision, which again he has decades and decades of experience doing. And he won't say, he'll say to the jury, you're the ones that have to decide what happened. This is a very difficult case to decide.
We need stuff from his CV.
Your medical malpractice expert example, isn't that an expert that's coming in to evaluate whether the standard of care was breached?
Yeah, well, so yes, usually we would offer an expert in that way, but given your ruling, I'm just trying to use that as an analogy where we could still use expertise that would help the jury without rendering that final opinion, telling them, as an expert, you should do this, and I'm really the one that knows because I have tons of experience. Instead, he can say, here's how I evaluate these accidents, and let me show you how to do it. And then they have rational principles that come from his field of skiing and ski accident evaluation that help them, that they have not heard. They haven't heard from any ski expert that has provided to them that kind of a rational layout for analyzing the various complex claims in this case. And I think that would help them.
Sure. And I think in my preliminary ruling on this witness the other day, yesterday, I'm losing track of the days here.
Yeah, me too.
I think I stated that he is qualified, certainly has qualifications, and can testify as to what a reasonable skier would do or not do in a certain hypothetical set of facts. But in terms of applying and weighing the evidence in this case, I think that goes too far.
Okay, so, but if we showed the animation and we made it clear to the jury that we're assuming certain facts, we're not.
They're going to lose this witness and the animation.
Weighing them. We're
Don't
just
think they're
saying,
going to be able to show the animation.
Let's
with
take
it.
these facts. We're assuming them. We're not saying that they're proven. We're just showing you how to analyze the facts, assuming these various parts of the testimony are true. That would be too far, you're saying?
That sounds like closing argument. It doesn't sound like what a witness can offer under Rule 702. He can talk about, he's an expert in skiing. He can talk about skiing dynamics. He can explain what a snowplow is, what parallel skiing is.
Owens is trying to get Clark Kent's attention here.
Of skiing are generally understood to be. But in terms of taking that next leap, I don't think he can say, I've looked at the deposition testimony and I can tell you who's at fault here, or I can tell you who did something wrong here. I just don't see. I think that's the jury's responsibility, and I don't want a witness telling the jury how to make its decisions or how to make a decision that's either an ultimate issue or one of the issues leading up to that ultimate issue.
So even him explaining his process for how to evaluate ski collisions would be too far?
To what end? Why does the jury need to know how he evaluates a ski collision?
Because evaluating ski collisions is a complex matter, and he has expertise as to how to do that.
Yeah, right now I'm just talking I'm responding to your question sort of in a vacuum. I don't know what it is he's offering.
If it would help, I could give you kind of an example.
Sure.
If I could say, Mr. Bager, when you evaluate ski collisions, and you've evaluated, have established that he's evaluated hundreds of ski collisions. Have you ever evaluated collisions where there's conflicting testimony? Yes. When you approach that testimony, what are principles you use to evaluate that? And he can explain those principles. He doesn't have to talk about the facts of this case. He can explain, here are these principles. I don't think the jury's heard that. I think it would be helpful to them. I think it would be rational and it wouldn't be overbearing.
You're asking him how he evaluates credibility.
Do you see the bailiff talking to the gum-chewing girl?
I guess that's true.
How does he reconcile different accounts?
Right, but we wouldn't, if given your ruling, we wouldn't go into applying it to this case. We would just give them the rational principles that would help them weigh the evidence. It wouldn't tell them how to do it. It would just give them a framework for doing it, which only he can provide. They have not heard from somebody that does this for a living, has done it, again.
And how does that vary from what the jury does? If you look at the credibility jury instruction that I've already read, for example, and how does that differ? I mean, where it talks about conflicting testimony, how does what he's offering provide any specialized knowledge? I consider that generalized.
Yeah, so I don't think he would just talk about general principles of evaluating witnesses. He would talk about particular aspects of a ski slope or witnesses on us. If he were here right now, he could help me. Yeah, right. He is right here.
So when ski accidents happen,
standing in back,
and people go to the ground, their skis get released. I could see that as specialized knowledge, just like this witness offered something along those lines.
Yeah, no, that is an important thing. He can explain.
But in terms of this skier said such and such, and this skier said such and such, but this is how I evaluate that aspect of it. I think that's invading the providence of the jury.
Okay.
On deciding how to weigh testimony.
Okay. I mean, for the record, if I may, Your Honor, I think we put this on before, but in case we didn't, we believe the motion to exclude Dr. Bogger or limit his testimony is untimely, and that Greg Skordas, their expert, whose report does much the same thing that Mr. Bogger's report does, should be limited in the same way. Again, just renew our request that he be able to speak to the jury about his evaluation of the ski accident.
So just again, my sort of ultimate conclusion on what I'm hearing on this motion to reconsider and on the response from the defense is that it's up to the jury to decide ultimately what the parties did, where the parties were positioned, and who ran into whom. So it's up for the jury to make those decisions. So as long as this witness steers clear of those areas, that's the main emphasis of my preliminary ruling, and I'll have to hear what's being offered.
Okay. Do you mind? I know I'm not an old man, but my memory has failed me. Those three again. Who hit whom? Going backwards.
It's up to the jury to decide ultimately what the parties did.
Right.
In other words, leading up to, during, and after the accident. It's up for the jury to decide that. And various experts have given them some helpful information, like the biomedical expert gave testimony as to what the biomedical evidence reflected that would help the jury make that decision. Just like this past witness gave the jury some biomechanical information that will help the jury make their decision about what happened in that accident, what the parties did, where the parties were positioned, and who ran into whom.
And the reason that you see Mr. Bogger as doing something different than, like, say, Dr. Schur just did, who took the jury through assuming these various facts. I'm not telling you that this account is true. I'm just taking as an assumption what Ms. Paltrow said was true. Let's analyze it. You're seeing Mr. Bogger as different, and I'm not totally sure how. Do you mind explaining that?
The plaintiff's witness applied biomedical principles in a methodical way to the different versions and then handed the jury that information. The biomechanical expert that just testified applied biomechanical principles to the different versions and gave that information to the jury to help them make a decision.
Okay. So
and what I see this witness doing is reading different accounts and reconciling them and wanting to give his reconciliation to the jury, which I think is too close to what the jury actually does. It doesn't help the jury from an expert standpoint.
Okay. So it sounds like you're not persuaded of our position, which is that he has skiing expertise similar to like a biomechanical engineer has, and can apply that to the facts in a way that would provide the jury with some, again, rational scheme to assess the accident that they wouldn't have otherwise.
Under Rule 702.
Right. Okay.
And the same is likely going to hold true to Mr. Skordas' testimony.
Okay. And you say likely.
I haven't. I mean, I've heard you make kind of a motion. I haven't heard from the other side whether they're opposing that in some way.
I see. You're just waiting till you have more specifics.
I mean, if he's the same type of an expert, and I realize that he may not be a risk manager, and he may not be a ski accident investigator for an employer, but it sounds like his testimony is along the same lines.
Right. Okay. So. Just in terms of guidance on this ruling, you mentioned the findings, and I apologize if we're going long. I just want to make sure that we...
You heard me.
Specialized knowledge,
right? So
that can help the jury in making their decision.
So in your mind, would something like recognizing that the positioning of the skiers, if one skier is uphill, applying a certain knowledge of skiing, that would suggest certain things about the accident. Would that be out of bounds?
I guess I have to hear the question, but it sounds like you're getting back into making conclusions based on an investigation. If you lay out some hypothetical facts to say if this skier was here and this skier was here, from a skiing standpoint, and then ask questions based on that, I could see that, but.
Okay.
It's feeling a little too hypothetical right now.
Sure. Okay. Thank you, Your Honor. Thanks for your patience with my questions.
Sure. Ms. Van Orman?
Yes, just really quickly, circling back to why I raised this in the first place, is the concern with the animation. And so what I don't want, because Mr. Bogger apparently had some involvement in creating the animation, which was not designated in his report, nor was any mention on what his involvement was, what he did for it, how he placed anybody anywhere. There's no discussion of any of that. I don't think that it's appropriate for him to comment on the animation and to say, well, yes, I saw that. This helps me because I'm the one who helped to place these people there. It would have been, again, by reading the depositions and applying, which is what the jury needs to do. So I would say he can't even talk about the animations because that just goes beyond the scope of his report, anything that he's done in the case.
I would agree.
Okay.
I would agree.
Then they might not even call this
Unless
witness.
The foundation can be set.
I haven't heard anything that would establish a foundation.
We have been broadsided, Your Honor. We had a 37-page report produced a long, long time ago. There was a motion deadline that we respected months ago. These issues were argued 45 days ago, and then immediately before our witness is going to take the stand with this 37-page report, we get essentially a midnight filing and that guts half of his opinions. I don't think it's fair, Your Honor. I can't even read the darn thing. I'm focused on getting my witnesses ready. The untimeliness is very prejudicial to us, Your Honor, because we can't properly brief this in days.
Okay. I've already ruled that the initial motion was timely, and I made a ruling on the initial motion. The subsequent motion was not untimely. The court has agreed to reconsider the motion, and that's what I've done. And I don't feel that it's unfair or unduly prejudicial. You were aware of the issues with his report long ago.
But you ruled in our favor before.
What I ruled was that the initial motion didn't give the court enough to grant it.
Because they
and so then there was a motion
briefed it.
Then there was a motion to reconsider that gave the court more information, and I can see that it would be. I mean,
you can't poorly brief a motion.
I mean, this would create an appealable issue. Do you want to do that for your client? Is my question.
No, but I don't want to. They poorly brief something. The judge denies it. Then right before the testimony, they better brief it, and now we lose. I mean,
that's what trial is. This is trial. Things happen. The points that were raised in the motion are valid points. They're sound. They're based soundly on the law, and I want to make sure that what the jury hears is sound and not subject to any more risk of appeal than possible. So we'll take 5 before the jury comes back.
That was a big L for Gwyneth Paltrow's team. You can hear how they presented that. Is that camera crooked? I think the camera's a little crooked. Just a couple degrees, and now it's going to bug me. How's my throne doing, Cachette? It is doing great. Thank you for asking. The witness is literally standing at the back of the trial. He's an expert witness, expert because he, analyzes ski crashes. I'd never heard anything about his credentials. I thought initially that was what the objection was going towards in this third sidebar of court. I guess that we won't call it really an objection because it was a sidebar. It was the content of the sidebar. But witnesses standing in the back of the court. They've literally called him. They're ready to bring him up, and now they've neutered his opinion, for lack of a better term. I don't know what else to say there. They've severely limited what he can testify to. They've zoinked the animation that he can testify and demonstrate and talk about. Yeah, it's going to be at this point. I would not be surprised if the defendants, if Mr. Owens said, in that case, we're not going to call him because you've taken everything from us. There's no benefit to calling him. Now, they used as much time as they would have used had they actually called him and gone through everything, so there's no plus side for them because I know they're short on time. And there was a question earlier about the timing and how it works. By a show of hands, how many of you guys have ever watched a chess tournament, like a professional chess tournament? Not a lot of people do. Some people watch them a lot. I've watched a few. They're interesting to me. My brain does not go as fast as the brains of the people who play. But the chess tournament has a timer. You've got two people facing each other with a chessboard in the middle, and they have a timer, and there's a button that's on a lever in front of them. And when the person on the left, it's I think that's your left. It's my right. Makes a move. They hit the switch down, and it starts the timer for the other guy. And then the other guy makes a move, and they hit the switch, and it restarts the timer on the other side, and it counts down. And there's like I don't know. They might have 25 minutes. I don't even remember. It's like a shot clock for each one. They have a countdown. So the trial is X number of days long, and they divide it up between the two, and they're supposed to have an even amount of time. And so every time one side is using time, it's counting off their side. So you can have you can use up all your time before trial is over. That's my understanding. If I haven't thoroughly confused it for you, I can try to explain it one more time and do that. But fancy timer in the corner, not mine. That one came from the courtroom. So we saw the girl in back had a little talk with the bailiff, and I think she got called out on the chewing the gum and probably the bubbles as well. She does not appear to be chewing anymore. We also have Mr. Orange Shirt, who may have been asked to leave because of his reactions. We heard from Danny on direct on her live stream yesterday that I was following, that she was saying that on that the court's very strict about reactions, and she was trying to be very careful to not to react in a way that would get her kicked out of court, because they apparently have been doing that. So it's possible that Orange Shirt might have gone too far because his reactions are drawing the attention of us, the viewer, and I'm sure the court and the bailiffs and everything is monitoring that feed as well, and I'm sure they saw that. So maybe he's just out on a quick break trying to talk to one of the witnesses as they're leaving. Maybe he's going to come back in. We're not sure, but he likes to be in the camera view, and I don't know who he is. Do you think the defense is going to get nasty because of that, Eddie? I think this is about as nasty as they get. Obviously, it gets a little bit more than this when it's between the plaintiff and the defendant's table. They get a little more so than between the defendant's table and the judge. Clearly, you're in the judge's throne room. You don't insult the king when you're in the throne room, and so this was about as spicy as you're going to see it when it's involving the judge directly in the conversation. But when it's just back and forth, it'll get a little more of an edge to it. Let's see. Don't like gum in court as mucky buggers stick it under the chairs. That's awful. That's just awful. Okay, judge is back. Timer's still going. Timer's gone. When you run out of time, you're done. The other side just gets to talk, and you don't get cross or anything. The GP would probably get told, and I think she was told to dial it back a little bit. That's just my guess, because she has changed from how she was behaving at the very beginning. But they probably aren't going to kick her out of trial because it's sort of her thing. She's the defendant. He left when the jury left. We're going to see if he's back here.
Yes.
Just admiring the judge's robe, the pleats. Looks really nice. It looks comfy and not too hot. Although my chair, I think, is better than his.
Okay. I didn't hear anything, so they went to get the jury. I see that.
Oh, I had my phone dictating. The voice feature was turned on.
Thank you. Now, Mr. Owens, you may proceed.
It's James again.
Okay, Mr. Egan?
We call Paul Bogger our ski expert.
Thank you. Mr. Bogger? If you could walk right over here to the clerk, and she will swear you in as a witness.
Do you swear that the testimony you are about to give in the case now before the court will be the truth, the whole truth, and nothing but the truth, so help you God? Thank you.
Good morning. Would you start by sitting down and then giving the jury your full name and spelling it once you get situated?
Thank you very much. Yes, my name is Paul Bogger, Paulbaughger.
Your Honor, I note that my computer is still there. Do you mind if I grab it?
Sure.
I was wondering where that went. His mustache looks
Mr.
sad.
Bogger, thank you for being with us.
Thank you.
Will you tell the jury what you understand to be your role here today?
Yes, I was retained to do an investigation to consider all the circumstances involved in the accident that you've been sitting through here. And I've also been asked to, if asked to assume certain facts, I could give opinions as to how that might work. Would that be plausible? Do I see this? I think maybe a lot of what I would hope to add today would be to sort of give the operational side, the skiing side, the things that we observe in accidents, and when we evaluate them, what we learn and what I pass on. I do a lot of teaching and training, which we can get into, but those are, I think, the key areas.
So do you have expertise to help educate the jury about the skier responsibility code?
Yes.
Or just reasonable principles about how to ski?
Yes.
What about how, like, for example, bindings and ski equipment might factor into how they might work in a certain collision?
Yes.
And why do you have confidence that you can explain that and with authority to the jury?
Well, I've been involved in working professionally in the ski industry for 37 years, and I've primarily focused on the outdoor, on snow, skiing, more specifically ski safety. That involves ski accidents. I do a lot of ski accident investigation. I mean, literally thousands and thousands. And I've done a lot of collisions. I've worked on a lot of collisions, and I haven't just done it at one ski area, my home ski area, but I actually had 4 ski areas that I did risk management oversight for, and I'm primarily a patrol director at my base, but then I moved into more supervisory roles that started to involve other ski areas as well, including one in Canada, one here in Utah that you're probably familiar with, Brighton. And those experiences of looking at these accidents in a variety of locations has given me quite a bit of information I can use to, A, do the day-to-day use of that. Do we need to address certain issues on the hill? Do we need to remove a skier, for example, if somebody's unsafe? In bad collisions and bad accidents, we really do need to learn as much as we can. We get medical feedback. We just consider a lot of information. And then the last piece of that is I pass a lot of that on. I've been training and teaching people in the ski industry about accident investigation, skier collisions, skier safety for the last 20 years. And so I've been all over on that.
Do you have any higher education?
Yes, I have a degree in economics.
And what about
economics?
Certifications that are related to ski sports or skiing?
Yes, I would have a number of certifications. I'm not sure how many of them would bear directly on the ski accident part, but I'm an EMT, an instructor of outdoor emergency care, a licensed blaster, an aerial blaster, which means we can use explosives from helicopters and mostly for avalanche control. Well, I guess only for avalanche control. If there's anything else, probably be a big problem for me. I'm sure my license doesn't say that. But and then I have a number of schools that I've attended, avalanche schools and various ski risk management type things. And then, as I said, really the last 20, 25 years of my career, I've been mostly teaching and training others, whether it's the National Avalanche School, which we actually just held here in Utah in the fall, or consulting for ski areas, working with the National Ski Areas Association on national safety campaigns. The National Ski Patrol System was on the National Safety Board, and so there's a lot of related things, but I think that's the gist. I've been involved in, I like to even say, as I've been referred to as an expert in this for a long time, and I've done a lot of trials and testimony on ski cases, but I always think of myself too as a student. I'm continually learning about it. I always want to know the next thing, and you think they're all the same, and a lot are fairly similar, but there's always something new and something different. So,
have you ever, in your capacity you mentioned of reviewing cases for litigation or giving testimony in court cases, have you ever done that in Utah before?
Yes, I had a...
When was that?
Well, I've had a number of skier collisions that I've investigated here now with Brighton. That's more my oversight, and I'm reviewing the accident records. And then when we have a bigger collision that has more issues and so forth, or a ski accident for that matter, I'll get involved and I'll start going through a review much like we've been doing here. And I had a trial, I think 3 or 4 years ago in Salt Lake, Solitude, the ski area, was involved. And Park City, I've had a couple of collisions at Park City that I've done expert reports and so forth. But those cases settled. But anyway, so yeah, and that's, again, I think what's different about what I do than, say, maybe what Mr. Graff would have been doing when he was the patrol manager, is that I do travel and I do go to all the different parts of the country, including the East Coast, for accidents and the investigations. And skier collisions happen basically everywhere, and that's been I'd say I've probably had 20 cases that have gone to trial that I've been involved in. Maybe they haven't all gone to trial, but at least that have been in litigation.
And are you aware of any studies, or have you done any measurements of how common ski accidents might be?
Well, I'm certainly, I work with people who actually are involved in the what we call the 10-year interval studies, and there's been 4 10-year interval studies about ski accidents and the mechanisms of ski accidents. I look at that data. I also, excuse me, I think you heard Dr. Scheer earlier describing the ISSS, the Snow Sports and Trauma, so the International Congress for Ski Safety on that, and I've presented there. I've presented I can't probably keep track of all the different meetings and groups that I've presented to, but these are bigger groups, the ISSS, and then I also present papers and do peer-reviewed work. The International Snow Science Conference, ISSW workshop, hasn't that was dreamed up in the 80s. They haven't lost that part of it, but it's a conference. It's an international conference. 1,000 people there. I do reports on things that happen, ski area problems, in fact, one ski problem with the snow immersion suffocation. I don't know if you've heard of that. You might have heard of tree well fatalities. Did you remember? We just had one here in Utah. And so that would be something I would gather data on. I talked to the general manager of the ski area that it happened adjacent to, and talked to the folks from the Avalanche Center here, Forecast Center. And they have some educational outreach that they do. And I basically was at the front of the snow immersion piece. I helped coin that term, and we did it. I keep a database. I keep doing ongoing research. I see you have another question coming.
No, it's fine. Well, I just, if you don't mind me interrupting, so when it comes to measuring how common ski collisions might be in a given region or in a given place at a given time, do you have any particular data you can offer?
Yeah, well, certainly. If you looked at, I mentioned those interval studies, the rate in skiing accidents, the total skiing accidents of collisions, is about 6 to 7% of all of the reported accidents. Now, I'm sure there's a lot of collisions where people just bump into each other and go on their way, probably a lot more of those. But ones that result...
Your Honor, I'm just going to object that I'm fine if this is just background foundation on Mr. Bogger's experience, but this goes beyond anything contained in his report.
I see it as background, so overruled.
Yeah, that's fine.
That was objection from the plaintiff, number 4.
Yes, so that rate at 6 to 7% is sort of uncanny from interval to interval. So 40 years of data now, and it's still the same. And now I use that metric myself because I'm looking at the 4 ski areas that I'm supervising, and then the other ski areas that I go to when I do investigations, I look at their data, because the first thing I want to know is what is that rate here? And it can vary throughout the season based on weather conditions and snow surfaces and so forth. But that's a metric, is are we doing okay? Do we have a problem? Is there something that needs to be addressed? And so I look at it. Well, in all accidents, there's all kinds of data you can get from accidents, not just skier collisions, in that way, and then we try to pass that information on. Sometimes we target it towards safety outreach. You can look at a lot of safety stuff on the National Ski Areas Association website that anybody can log on to and look at the safety pages, and a lot of stuff on collisions that's in there and skiing safely and so forth. I had a lot to offer in the production of all that.
Thank you. Do you have any knowledge of what the rate of ski collisions might be in Utah? How common they are?
Yes, and it would be almost identical. Yeah, there might be, again, minor variations from ski area to ski area, but if you looked at Deer Valley, for example, which I did, and I asked this question during my site inspection, and their rate is just right in there. It's probably 6%, 7%.
How many collisions, and I'm talking not ski accidents, but collisions where two skiers are hitting against each other, how many collisions like that have you investigated, evaluated in your career?
Yeah, I looked through sort of back through the accident review data that I keep, and to just look at what you saw the other day, the incident report form, and maybe it's got something like an additional patroller comment or a ski instructor's incident report. I looked through that and I figured there have been about 4,000 of those that I've reviewed out of about 44,000 accidents with just the incident report form that I've looked at. That's all accidents, but collisions, about 4,000. And then things that really got more investigated where there was things like we're doing here, 550 is, so that's a lot of accidents and a lot of collisions.
In those collisions?
Over a long period of time.
Sorry,
I just wanted to make sure. Yes. And nobody will think skiing is safe anymore. I wanted to finish that.
So when you've done those evaluations, what is your role? What are you trying to accomplish as you evaluate those accidents?
Well, sometimes we need to find the cause. Mostly we want to know the cause, and certainly that's how you can target prevention. But we also want to learn circumstances. Sometimes we have really bad injuries in these collisions, and it's important for us to make sure we know, is there somebody at fault? Are people meeting the responsibilities? And so we're looking at that all the time, and part of that is we want to make sure, since we're all responsible as skiers, that includes the ski areas, me, you, if you're skiers, that we share safety and we all do it together and we all have responsibilities, and if one of us is not doing our job, people get hurt. And so we need to evaluate fault at times, and we maybe address some people that we actually remove from the mountain. We've had people go in cop cars off of the mountain, but we're serious about it. We want our skiers to know that we're serious about it, and they feel okay bringing their kids there, that we're not just turning a blind eye.
So in your evaluation of these various collisions, what have you learned about what the inherent risks of skiing are?
Well, certainly skiers face a variety of inherent risks, and those are often codified into especially in states that have a lot of skiing in them, like Utah or Washington State or California. There's what they call like a ski safety statute in the regs, and so it will mention many times, it'll enumerate what some of those inherent risks are. Another place you can find those inherent risks are on trail signs. Are mandatory here in Utah, and that they're publicly displayed, but also the ticket back, sometimes that varies from place to place. But do you want me to list any of the inherent risks? Or?
Sure, yeah, just to educate the jury, given your experience investigating these various collisions and just your experience as a long-time advanced skier, what are those inherent risks?
Objection, Your Honor, relevance.
Overruled.
That's number 5.
Thank you. Yes, so things that you encounter as a skier, things that you could likely have a problem with if you weren't paying attention and weren't following your role, your duties of things that we would identify under things like the Ski Responsibility Code, which we can talk about. But terrain changes, forest growth, bare spots, things that you might run into, objects, lift towers, grooming machines, snowmobiles. We try to keep those off the hill when people are around. But, that's part of the sport. People need to get, lift maintenance people need to get around the mountain. So snowmobiles would be in there.
Oh, sorry.
Yes, go ahead.
I was just going to say, what about inherent risks relating to ski collisions?
Yeah, and that's where I was coming to. Yeah. So I wanted to give you the broad brush and then say, and things like inbounds avalanches, you can actually get, even if they do the mitigation, you can actually get into an avalanche inbounds, and that's a risk you hadn't seen identified for a while, but about 5 or 6 years ago we started adding that one, and collisions, skier collisions, or even collisions with lift towers and objects. But skier collisions, as we know, 6 to 7% of the accidents, we can eliminate some things, but an inherent risk you cannot. And the definition there is the risk is inherent in the sport. You cannot remove it without fundamentally altering the sport as it exists today. So that means following our good responsibilities and being prudent skiers, we can reduce the risk, but we can't eliminate it.
So does that mean that sometimes collisions occur despite people reasonably skiing on both sides of an accident?
Yes, that happens all the time.
And when you investigate collisions, do you sometimes, after a thorough review, conclude that you can't determine who was at fault?
Yes, that's common.
So just to put that in another way, in your evaluations, will you come to the conclusion that a certain accident is, and the evidence that you received in gathering information about it is not clear enough for you to identify who is responsible for it?
Yes.
This witness is at
Let's talk
mustache.
about the skier responsibility code. You mentioned that.
Yes.
And it's been brought up before, but since you're the ski expert, let's have you teach us about it for a second. I believe it is defense. Give me just a second, sorry. Thought I had it right here. Yep, it's defense 91. Any objection to that being published? Or I guess I should talk to the judge.
No objection.
91 is received.
Okay, so let's put this up on the screen. It's also on your screen right there, Mr. Bogger.
Yeah, thank you. I see it.
And I'll turn it here so it's a little easier to see. Okay, so is this the skier responsibility code you were referencing earlier?
It is, and it's actually changed in the last few years, but that's the one that was in existence at the time of this accident.
Okay, got it. 2016.
2016.
February.
2016 February, that's correct.
Okay, and how do you know about this skier responsibility code?
Well, it's key, excuse me, it's key to all of the duties that we were just talking about in order for people, the skiers, for us to do our part. And it's a national code, started back in the 60s with the National Ski Patrol system before they had professional ski patrols at ski areas. And it's used all over North America. Canada has something called the Alpine Responsibility Code. It's very similar. It has a few more details on it. I've testified in trials in Australia talking about a code that they have, again, very similar to this. But these are basic rules of the road. You have to give people, so you can put some order into the chaos that is skiing. You know, skiing's very dynamic, as you know if you're a skier. And so you're trying to put some basic rules in that people can follow, their common sense. And, go ahead.
Do you know, are there ways that skiers can become familiar with this responsibility code?
Yes, this is published at all ski areas. It's on trail maps typically, and you'd find them on big trail signboards too at the ski area. Websites will have it. There's all sorts of places you can go to find this, but it's everywhere.
Okay, and let's talk about the particular points here. I'll pull them out. Maybe should we just go through them one by one? Is that okay?
Sure, however you want to do it.
Okay, so the first one, always stay in control and be able to stop or avoid other people or objects. That seems fairly common sense.
Yes, that's if that one doesn't work, the rest of them aren't going to work.
And then the second one maybe is more important. People ahead of you have the right of way. It is your responsibility to avoid them. Can you explain what that means for skiers?
Yes, and the presumption is when people are skiing down a run, the people in front of you aren't going to have that rear view like you would. You'd be in a better position as an overtaking skier to see the people in front of you.
Got it. 3 is you must not stop where you obstruct a trail or are not visible from above. What does that mean?
Well, again, it's just about being visible. And so if there's a breakover in the terrain and you were on the bottom side of it, the skier that's coming from above isn't going to see you. And so it's to prevent surprises. And again, if you're skiing in control, if you're following the first rule, when you're coming up to terrain changes, that's one of the things that skiers have to manage is their skiing, their speed, their rate, their course, and most importantly, their lookout. That's what allows them, even if they come to a terrain change and there's let's say a small child taking his skis off on the downside of that hill, you're not going to run into him even though that person might not be following the code. You're not following it either if you just go tearing over the hill. You have to be able to be in a position to maneuver so you don't hit anything.
Okay, so if a skier were taking, are you familiar with the term GS turns?
Yes, giant slalom.
If a skier were taking GS turns, what principles here should that skier follow?
Well, with a GS turn, and again, just backing up for a moment, skiing is very dynamic. It's people that are changing positions relative to each other all the time, and people are going at different speeds. People are using different styles, and you're mentioning one of them. You know, short radius turn or a slalom versus a larger radius turn, more rounded turn, a giant slalom. And these are different styles, and there's no prescription for how you have to do it or even what your ability is, any of that. There's no speed limit. I mean, there's slow skiing areas, but there's no number. So the idea is skiers have to be able to be in control, and it's the lookout. In a GS turn, you're taking wider swaths of terrain. You're moving across more, you're using more of the available hill space. So again, if there was trail density that was suggesting maybe you should be skiing shorter radius turns, that would be a reason. But typically when people are skiing giant slalom turns, their speed is usually faster. And people that are skiing short radius turns, I mean, if they try, they can ski quickly, but most of the time, the turn is what controls your speed. So if you're making more of them, you're probably going slower.
What about, let's assume a skier is overtaking another group. They're skiing through a group that's skiing slower. What responsibility does that skier have?
Well, again, as the overtaking skier, you're looking at the rule number 2, people ahead of you have the right of way. And when you're coming into a group, you now have less space to maneuver. And your lookout has to be sharper because you have more things to focus on. Again, remember, everybody's not moving in unison. They're moving dynamically, and people can turn suddenly. And so again, if you're a prudent skier, and this isn't necessarily covered in the code, but if I'm going to make an abrupt turn on a crowded run, that's a problem for me. If I didn't look, I need to look up. It doesn't say you have to look uphill, but so the code gets you just so far. And I think, if I may, one of the things about the code is if you try to look at any one rule and say, for example, in a collision, because I have to look at this all the time in these investigations, or when I'm training people, I would have to tell them, never focus on just one. That's just one part of the puzzle. There's usually something else. And if I had a penny for everything that was involved, the failure of the lookout. For example, if I might have two skiers in a collision, and both are trying to be not the uphill skier, and I look at them and I'm going, but you were changing your positions, you had different speeds, you were merging and converging on each other. You both have the responsibility for your lookout. It can't just be straight ahead. You have to be looking, and that's part of why you have to go to number 1, and that's the king, and then you go through the rest of them, but you can't hang your head on just one. Now, in some accidents, it may be really prominent, and you can weight it that way. But I'm just saying, you need to consider all of this, and the lookout you can't forget.
Right. So, is there anything about...
I don't
What
know.
can you tell us about the rules of skiing reasonably that relates to skiing within your ability? Is that one of the rules?
Well, it's not a rule per se, but it is right here that you have to be in control. So that means for whatever slope you're on, whatever the snow surface might be, it might be a hard, icy day, and you're going faster, it might be a little harder to control your speed. You know, you need to then, it's not that different, I guess, from driving there, because, you know, if the weather's bad and your braking distance is bad, then you have to give more room. And I think creating space is a key, but you have to ski within your ability, and you want to assume that maybe not everybody's doing the same thing, and leave a margin.
Okay, so what about if take an example of a skier that may have certain physical disabilities? Does that skier have the responsibility to take account of those or those limitations and ski appropriately?
Yes, of course.
Let's move away from this for a second and ask you about a hypothetical that connects to Dr. Scher's testimony. You were here when Dr. Scher testified earlier,
I was.
Correct? And he talked about bindings releasing. Do you remember that?
Yes.
And do you have knowledge about how bindings release in ski collisions?
Yes, I do.
So if you were to assume a certain skier came and hit another skier directly in the back at a high rate of speed, would you expect bindings to come loose, the skis to come off the skier?
Objection, Your Honor. Lack of foundation also not contained in his report in the least. There is nothing mentioning any binding release anywhere in the report.
Objection number 6.
Sustained.
Let's take another hypothetical.
Good luck.
Give me a second.
I think you're going to start to see a lot more objections here. They might have gone to the limits of what they can get with this witness already.
Let's forget about bindings and use that same hypothetical of someone skiing directly into someone else's back. Would you expect that person to launch over the person they hit, a couple feet down the mountain?
Same objection, Your Honor. Lack of foundation.
Sustained.
Number 7. This witness, his mustache is so
is there a
amazing.
space
He hides his
on the
upper lip
hill
completely,
where
and I can't see him mouth words.
Skiers, where you let me think about it differently. If a skier were trying to avoid collisions and ski in a kind of safe and cautious place on the hill, where should that skier go?
Well, you could look for certainly terrain within your ability, and if you want to be cautious, you'd probably want to be on easier runs. And if you were wanting to be away from more people, specifically if you're concerned about skier collisions, and runs are getting crowded these days, you pick the right time, or you wait for opportunities. You can wait for traffic to go by, and then you can go. Staying on the margins of the run is usually good, because you only have one side to defend, if you will.
So if a skier were taking short radius turns on the right side of a run, would that be within the parameters you've just described?
Yes.
Thank you, Lisa, for that description. Uphill skier is the one who is farther up the hill. They're not actually skiing uphill.
I did cut you off a little earlier when you were talking about the inherent risks of skier collisions, the things you learned about what the inherent risks are in skiing, investigating collisions. I want to make sure you got out what you wanted to on that point. Was there anything else?
Well, I mean, that's a big question.
Objection vague.
Sustained.
Okay, Your Honor, may I take a second to consult with my counsel? Thanks. Sure.
I think he might be done. See, I called it. He's at the limits of what he can get out of this witness with the restrictions the judge has placed on them. Might have a couple questions or two they're going to go at, but I think you're going to see objections every time they do, especially when he starts getting into hypotheticals, which basically means that this witness was probably a big waste of time. There's not really anything we've heard from him that we haven't heard elsewhere, or at least has been brought up at other times during the trial. Consulting with Man Bun. That's digging deep in the barrel.
Okay, thanks for your patience, Mr. Bogger.
Sure.
You personally went to the site of this collision, correct?
I did.
And were you there when Mr. Brill, maybe I should ask first, do you know Mr. Brian Brill?
I do.
And who is he?
He does animations, the ones that you've been seeing here, and he does them all over. For ski accidents, I think he does other things too, but he's very, very precise in laying out the terrain and the features in the terrain. That, the trees are all the right height and the shadows are correct and all of that.
Yeah, and you were here, and you'd seen the animations before, correct?
I have.
Objection, Your Honor. This goes beyond the scope of his report. There's no mention of animations in the report.
Overruled at this point.
And
I need to see how it's tied in.
Sure. I was just going to ask that given that you've been to the site of the collision, does the animation to you accurately portray the
Here comes an objection.
Objection, Your Honor.
Sustained as to relevance, it doesn't matter. It was a demonstrative of the other witness's testimony.
Okay.
I think they're done.
In this case, what did you review?
I looked at all the deposition testimony, the documents, and various forms. We did the site inspection. I did work with Mr. Brill on the animations. I talked to Mr.
Objection, Your Honor.
Graff.
Strike. Relevance.
Sustained as to relevance. Why don't we take our lunch break at this time? It's just a little afternoon.
That's number 11.
So we'll take a recess and return at 1:30. Thank you.
Thank you, Your Honor.
Okay, so this witness is awful. Has not provided anything really of substance for the defendant. And here's the kicker: Cross is coming, and I don't think he's going to do well. He is not the what was the guy who did before? The guy who's sitting in the back of the courtroom right now. The previous witness was incredible. There he is. He's got his back turned, but Mrs. Paltrow's going out.
Questions in light of the court's earlier rulings? Okay. We'll see you back at 1:30. Thank you.
We get an hour and a half lunch break. See that witness is walking forward right now with the big binder of stuff in his hand. He was the last witness. Did a very good job. Very good. We enjoyed him. Orange shirt is sprinting out the door to see somebody. I'm not sure who. Looks like media rooms across the hall, or that might be security. Anyway, lunchtime. It's lunchtime. It's been a little bit slow after a pretty good start this morning. So I count, defense has only had one objection. The plaintiffs has had 11. We've had 3 sidebars so far this morning. I think Lisa says, I agree. I think we'll struggle with Cross. They should have stopped at the diagram guy. Yeah, this one, as soon as the judge took their ace in the hole for this witness, because he was going to use some of the other diagrams or the animations and show, just hammer home again how they believe this happened. As soon as they took that away from him, they basically have nothing. So I realized they spent all this money. Maybe they have an agreement to pay him a minimum of a certain time, or how long he's going to be on the stand. I don't know. They just pay him his money, send him home. There's really not anything they can benefit from. And I think, honestly, he'll probably get hurt the case will be hurt more by him being on the stand, unless he just does amazingly under cross. And some people do that. I mean, some people are just incredible under cross. I just don't think he's one of them. So that's where we're gonna leave it for lunchtime here. Any questions we need to answer before we let everyone go and get their lunch? I admit I had already had mine. My wife made me a Philly cheesesteak sandwich, which was delicious. And they're laughing. They're watching a movie or something in the front room. The Pictionary Witness, that was the best one. I'm going to go back and try to get that screen grab of that drawing. We might need to put that on a mug or a shirt. We'll see if we can use that. Plaintiff is not going to win, says Andy Cutright. Not a lot of help. Enjoy lunch and dinner break, depending on the time of day. Crusoe, I'm not sure. Crusoe, you did a great job with the internet today. Congratulations. I think it was your first time, and you did phenomenally. Let me know if there was anything that went wrong. I didn't see any problems on my side. Abby says, Recovery Addict, for all your input. You cool? Yeah. You're welcome. It's a good day. It's a good day to be here with you guys. All right, we're going to wrap it up for lunch. We'll be back in about an hour and 15 minutes, which puts us at 3:15. Now remember, this trial, it's in Utah. It's a couple hours behind us, so it finishes later in the day. It means most of us are tired and ready to be done, and they're still going strong. So it makes it a sort of a drag at the end of the day, but we're going to stick with it. We've only got a couple days left. We have a hard stop date. The judges said this is the Thursday. I believe it's Thursday at noon or something. This goes to the jury. So, that's everything has to be done by then. Is that witness going to have KFC for lunch? After all, he's on the bucket. He looks sort of like Colonel Sanders. The mustache it bothers me a little bit because I like to make sure my audio is synced up with the video, and with his mustache covering most of his mouth, it was like sounds were coming out and there was no motion because he uses his top lip to move, and it hides everything. It was difficult as an audio guy for me to watch that and not have that confirmation of the sync lined up. Defense would win without putting up any witnesses. What does that tell you? Yeah, I think if we only had the witnesses from the ski resort, and that was it, and then we had the defendant and the plaintiff, and just had their stories, I think that's enough information for the jury. I think they could decide it by that. Thank you, Diana. Appreciate the #1 awards. I fell asleep listening to it and then rewatch in the morning. Yeah, this there's not much to rewatch other than the first thing in the morning was a little bit fun, a lot of spicy. The witness that drew the pictures, the Pictionary witness, phenomenal. That one I'd say rewatch that. I would rewatch that a couple times because it was really good. I think I'll get a couple screen grabs from there too and see if we can get some artwork created. Yay, now I can listen to Recovering Addict. Thanks, Mustang Guy. Do you think Owens will approach... How do you think Owens will approach the guy? We'll be on this one. We've got it's the lady on the plaintiff side that's going to be doing the cross. She's been you know that because she's the one who's doing the objections. Generally, you have one attorney does the objections and the cross or direct of a specific witness. So Owens is not going to be talking to this person. Owens is lining up the next witnesses. I don't know who they have next. We've heard it's a lot of expert witnesses, one after another today. Poll, no poll, sniff, sniff, go to lunch. Yeah, sorry, Eagles Prey. We did a poll a little bit earlier on, and that's why we stuck with the Gwyneth Paltrow case, as we were also looking at the one that started at Kenosha today. Did he cover the verdict watch or case of the ice cream truck murder? We watched the verdict watch this morning, Heather. That was the first thing we picked up. Got the guilties across the board there just moments before the Gwyneth Paltrow case started, so we just caught the end of that. We did not watch the trial itself. We just had other things. There are too many trials going on. We've got to pick and choose sometimes. And we chose Gwyneth Paltrow, or I chose Gwyneth Paltrow. That was my choice because we wanted something that was a little bit easier. It was a ski accident. There wasn't like death. There wasn't murder. There wasn't, it was. It seems like to be something lighter. Unfortunately, it had some heavy moments as well. But that's it. All right. I think that's everything. Let's do lunch, shall we? Let's do that. All right. Hopefully you're able to join us for the second hour. We're going to be back in about a little over an hour. So get some lunch, come back. We're going to open up the lines again. First person in chat will win the internet. Crusoe did a good job, but I imagine Crusoe will surrender power peacefully, and that transfer of power will happen smoothly as it should. So we'll look forward to that. Appreciate those that do click on the like button. That does help us out, and it doesn't cost anything. It's free. This case is awesome. It has its moments. It's really good. I hope that it gets better and better, especially as we lead up to the closings here in a day or two. I like this track you play. It's a good one. I love it as well. I'll see. Raw, how about this? If you come back after the break, I will have the name of this track for you, because it is available on YouTube, and it's royalty-free. It's copyright-free. It has a different name than the one I know it of as. So for you, I will find out the name of this track. How about that, Rob? All right. How naive we were. Will YouTube ever change the status of the main page? Still says upcoming. They've had trouble with that for about a week and a half now. But it's good. Yes, 9,870. I think that's where we're at. It's let me double check here. Wait for it. 9,871 on the subscriber list. So we are growing. We're inching closer to 10,000. We might hit it this week. That would be awesome. Anyway, if you're not able to return after lunch, please, tonight when you go home, hug the people you love, smile at someone, make their day just a little bit better, and please stay safe till we go live again. It'll be after lunch, but it'll be good. We'll see you in a little bit. Thanks.